Garden State GSCLE. 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 Garden State GSCLE.
We'll talk a little bit about judicial discipline, but our primary thrust is going to be on the RPCs. So let's kind of start at the beginning. And our starting point is the New Jersey Constitution of 1947. I want to just kind of begin with Article 6, Section 1, Paragraph 3. And you can see that in the section I've underlined here, this provision of the state constitution vests in the New Jersey Supreme Court the authority to impose discipline on members of the bar. This is something that's uniquely within the province of the New Jersey Supreme Court. And by that I mean that there's no other administrative or legislative body that has the authority to discipline attorneys in any way. And you got to kind of think about what this means from a practical standpoint, because you have administrative bodies that have been established by the Supreme Court to carry on the work of the attorney disciplinary system, but none of them has any authority to discipline anybody. So you think about the local district ethics committees or the disciplinary review board or even the Office of Attorney Ethics. They don't have authority to discipline anybody at all. All discipline can and must come ultimately from the New Jersey Supreme Court. Okay? Now, having said that, I want to just talk about the reality of how the system works. Your case will kind of be tried, and there'll be factual findings and conclusions of law done at the lower level. We'll talk about how that's done in a moment. But ultimately, your case winds up before the Disciplinary Review Board, which is a panel of, I don't know, sometimes they have 8, sometimes they have 9 people sitting on it. They'll hear your case. They decide it de novo based upon their own conclusions of fact and law. And then if they determine that there were violations of the rules of professional conduct, they'll come up with a recommendation for the level of discipline. Now, what they come up with is only a recommendation, because, as again, only the Supreme Court has the authority to impose final discipline. However, the Supreme Court really, the vast majority of the time, 95% plus, will accept the recommendation of the Disciplinary Review Board and impose that level of discipline. Okay, so if they say reprimand, it'll be a reprimand. If they say 3-month suspension, that's what it's going to be. 6-month suspension, that's what it's going to be. It's highly unusual for the Supreme Court to modify or reject a disciplinary recommendation of the DRB. And that's purposeful, because they want them to have the final word on it. It's such an enormously complex and I guess the right word would be kind of like a tidal wave of business coming through all the time. There's so much activity that the court just doesn't have the wherewithal, administratively or otherwise, to give individual consideration to each case coming through. So they rely upon the DRB to be their screening mechanism, so to speak. So while I don't want to use the word that the Supreme Court rubber stamps every one of their recommendations, there is some mechanism to review what they say. As I see on occasion, they will modify a little bit what the DRB says. Sometimes something will go from a reprimand to a censure, or from a censure to a reprimand. Sometimes, a 6-month suspension will be a 3-month suspension. But that's kind of an exception. The vast majority of the time, the Supreme Court will take what the DRB says, and that'll be the final discipline. Now, if you're going to be an advocate, one of the things you've got to say to your client is, listen, we've really got to put all of our best efforts into the DRB, because statistically, the likelihood of whatever they rule in your case, that's what you're going to get ultimately when the Supreme Court imposes a discipline in your case. All right? So, again, I don't want to shortchange the DRB in terms of their significance, because they are extremely significant, although the ultimate final discipline has to come from the Supreme Court. Now, the first part of this paragraph is also important, where it says that the court has the authority to, subject to the rule of law, the practice and procedure of all such courts. This is the grant of authority by the framers of our Constitution, which enables the Supreme Court to promulgate the rules of court, for which we're all so familiar, and collateral types of administrative regulations, such as the RPCs, the Rules of Professional Conduct. It's that grant of authority which kind of is the backbone, so to speak, of the rules of court and the RPCs. The rules of court and the RPCs work together to implement the disciplinary system, and you're going to see today when we'll talk about specific rules of court that kind of cross-reference the RPCs, and you've got to look at them and read them in pari materia because they kind of go hand in hand and in a couple of different areas that are of particular importance, all right? Now, the first example of this is going to be Rule 1:14, and 1:14 is the omnibus rule which requires New Jersey attorneys and members of the judiciary to comport their conduct in both their private lives as well as their professional lives in conformity with the rules of professional responsibility, the RPCs, and in the case of judges, with the New Jersey Code of Judicial Conduct. You can see that this, again, is an authority that the court has promulgated under 1:14 based upon the grant of authority in Article 6, Section 1, Paragraph 3. So this is why we have to comport our conduct in conformity with the RPCs, or the Code of Judicial Conduct, all right? Now, for judges, it's really all spelled out in the court rules, specifically Rule 1:18, in terms of the responsibility for enforcement of the RPCs. A judge who becomes aware of an RPC violation by an attorney is duty-bound to take the appropriate action to report it to the proper ethics authorities. Typically, that's going to be either the District Ethics Committee or the Office of Attorney Ethics. Those are going to be the two agencies where the reporting would go. Judges don't have any discretion in this matter. They have to do it 24 hours a day, 7 days a week. It leads to some very unhappy circumstances sometimes for everybody involved, because judges, they got better things to do than be reporting on colleagues who screwed up. I'll just give you a real quick story from a court I was in one night. It was the public defender in a particular court, and a defendant showed up and went up to the prosecutor. I was kind of standing right there, and he hands the prosecutor a business card, and it was the business card of a local municipal court judge who also had a private practice. This guy had obviously been one of his clients. And the guy showed up pro se, and on the back of the card was written, "Please give this man every consideration." All right. Apparently he had told the client to go see the prosecutor and hand him the card. So the prosecutor kind of, he freaked out because he wasn't sure what to do. He knew that this was a bad situation. He just wasn't quite sure where that put him from the from the perspective of conflicts and things like that. So he met with the judge in chambers, gave it to the judge, and now the judge knows about it, and under Rule 1:18, this judge, he just knew his responsibilities. He said, I got to go forward and do something, and he did. He turned it over, I think he turned it over to the ACJC, and they took the appropriate action against him because this would be utilizing the judicial office, the prestige of the judicial office, to advance the private interests of another individual. It would be the violation of the Code of Judicial Conduct. This judge wound up getting publicly disciplined by the Supreme Court, and everybody felt terrible about it because he's a good guy. Everybody liked him, and there was nothing wrong with him. He's just stupid. Made an idiotic mistake, and but the judge really had he just didn't have any choice based upon Rule 1:18. So that decision has been taken out of the hands of members of the judiciary. They have to go forward and do it. It is a much more difficult, nuanced question with respect to attorneys in terms of their obligation to report violations of the rules of professional conduct. It's set forth in RPC 8.3A in particular, dealing with members of the bar. For judges, it's under B. Let's talk about A for a second. Your obligation to report violations that you become aware of is nuanced. It is not universal. It's really, the best way to look at it, it's reserved for two things. Number one, absolute knowledge. In other words, something that you know exists or you're practically certain exists. That's number one. And number two, that, for want of a better term, these are things that are very, very serious, which reflect on either the integrity of the guy, of the attorney, or his ability to carry on the practice of law, or puts people at risk, especially clients. Take a look at how the RPC is worded. A lawyer who knows that another lawyer, so it's not what you suspect, it's what you absolutely know to be true, has committed a violation of the rules of professional conduct, okay, but it's not every violation. This is the qualification. It's a violation that raises a substantial question as to the lawyer's honesty, trustworthiness, or fitness as a lawyer in other respects. Now, the fitness of the lawyer in other respects generally is going to refer to health issues. So, depression, insanity, drug issues, something of that nature. Okay, shall inform the appropriate professional authority, which typically is going to be either the Office of Attorney Ethics or the District Ethics Committee. So this is not an absolute requirement. It's limited to those areas where you feel, based upon your knowledge, that this individual has engaged in something in the past. In other words, the act has already occurred. It's not prospective. That raises a question as to honesty, trustworthiness, or fitness. In the past, I've seen this come up in the context, say, for example, in a real estate closing, somebody shows up for a closing, and at the closing, the attorney pulls out a personal check, his own family personal check, and pays off the mortgage of his client with a personal check. Okay, things like this, they raise substantial questions. There's something crazy going on here, probably with the trust account. But regardless, this is something that has to be reported because of the gravity of the situation, and it may be indicative of something else going on. The problem with the RPC 8.3 is it has not been well construed at all in the case law. There's only really two cases to discuss it in any detail at all, Macaluso and Fusco. And they're both really kind of over-the-top cases. Macaluso involved a situation where you had two brothers that were practicing law together, one who was ripping off the trust account and taking the money to Atlantic City and gambling it away, and the other brother who knew about it and didn't do anything. And at the end of the day, the brother who was stealing the money wound up getting disbarred, and the one who knew about it wound up getting censured under 8.3a because he knew what his brother was doing, it met all the criteria for 8.3a, but he didn't take any action on it. I'm just waiting for the appropriate case to come along. There's really nothing that's been decided by the Supreme Court that construes this particularly well, or from the Disciplinary Review Board. There'll be a case someday that'll tell us and give it these distinctions. Now, for members of the judiciary, again, you have the same idea that there has to be knowledge, certainty to a certain extent. The violation has to have occurred already, can't be something that's prospective. And the triggering mechanism, again, is substantial question as to the judge's fitness for office. Now, typically that's going to be a health issue, that the judge is suffering from some type of mental disease or defect that makes it so it's inappropriate for him to continue on the bench. It's not going to be issues related to demeanor. It's not going to be issues related to incompetence or things of that nature. These are typically going to be health issues that prohibit the judge from doing his job in a way that's appropriate. There's no case law that has construed 8.3b yet, and I think people would be pretty hesitant to do that. And you hope that this will be taken care of long before an attorney has to make an application under that. I can't imagine somebody being disciplined for not reporting a judge under B, because there's other mechanisms for getting judges off the bench or addressing their problems before you have to get involved in B. Okay? Just remember on C, if somebody comes to you and has these issues, you're protected from revealing that with the normal attorney-client privileges set forth under RPC 1.6. Okay? Okay. Now I want to talk about burdens of proof. These are the citations on Fusco and Macaluso. I want to talk about burdens of proof for a couple seconds. The burden of proof in all attorney disciplinary matters is proof by clear and convincing evidence. I commend to you the case of N. Ray Seaman. Double A, can you get the citation on N. Ray Seaman, please? Seaman is a judicial disciplinary case involving a judge of the Superior Court who sexually harassed a young lady who had been appointed to him for clerkship. And in the Seaman case, the Supreme Court comes up with a definition for what clear and convincing evidence is. This is something that's been repeated numerous times in the case law thereafter. And paraphrasing, clear and convincing evidence is evidence that is so clear, direct, weighty, and convincing as to enable a fact finder to come to a clear conviction without hesitancy as to the precise facts in issue. Your knowledge of this is indispensable in terms of being an advocate in an attorney disciplinary case, because many times the level of discipline, even between a disbarment and some other minor discipline, is going to rise or fall just based upon whether or not something has either been proved or disproved by clear and convincing evidence. So, as a starting point, you need to know what the definition is. You should have a copy of that passage in Ray Seaman. If you're in a hearing before either a panel from the District Ethics Committee, before a special master, you should be passing a copy of that up to the fact finder. You should reference it in an opening statement and certainly pound away in a closing statement if you're in a fact fight, okay, where you're trying to say something exists or doesn't exist. It is indispensably important that you do that. While you may have people who are making factual determinations that have an idea about what proof by clear and convincing evidence is, what their idea is versus what reality is are two different things. Everybody has to be reading from the same script. You can't rely on the fact finder's personal predilections or theories or beliefs as to what clear and convincing evidence is. Rather, the Supreme Court told us exactly what it is, and everybody should be reading from the same script, so to speak. It would be like trying a criminal case before a jury and not explaining to the jury what proof beyond a reasonable doubt is, and the judge not charging the jury and defining proof beyond a reasonable doubt 4,000 times, okay? That's exactly what you want either way, no matter whether you're prosecuting or defending the case. So this is the same type of principle, and again, when you're in a fact fight, whether a particular fact is found or not found can make all the difference in a disciplinary case. It's just the way these things go. In judicial disciplinary cases, for the most part, it's proof by clear and convincing evidence as well. The only exception to that is for removal actions. If there's a removal action, that's the burden of proof is proof beyond a reasonable doubt. But for everything else, it's going to be clear and convincing evidence. This appears both in the rules of court, but it also comes through the case law. I think Gross is the case. All right. Now, I'd like to discuss Rule 1:20-15A for a couple seconds, dealing with the options that the Supreme Court has when they impose a level of discipline. And I'd like to begin by talking about something that's not on the board here, which is no discipline at all, okay? There is a program in New Jersey which allows attorneys to be diverted from the from the attorney disciplinary system. I want you to think about it conceptually as PTI for attorneys, all right? But it's better than PTI because PTI you can only get once in your lifetime, whereas this diversionary program is available theoretically every 5 years. You know, you can just get it, wait 5 years, get it again, and wait 5 years. There are certain preliminary criteria that you have to meet in order to qualify for the program. The first of which is that the nature of the RPC violation has to be relatively minor. You're not going to be able to get a diversion when you have theft issues, criminal issues, or an enormous amount of harm to a client or other individual. They're just not qualified for consideration for diversion, especially theft and crime type issues. But that's kind of a small minority of what RPC violations are all about. The more prosaic matters typically are going to qualify. Secondly, there are time considerations. You have to make your application before the case ripens into a formal complaint. Now, this is a critical distinction. I just want to kind of talk about it procedurally. The attorney disciplinary system at its inception for every case is a confidential, secretive type process. And the reason for that is to protect the reputation of attorneys against unfounded claims of unethical conduct. In order to kind of promote this, there's a couple of things that are inherent in the system. One is that the secretary of the district ethics committees, who kind of field these grievances and inquiries from members of the public, disaffected clients, etc. They have tremendous discretion to investigate these cases and dismiss them if there's no merit to them. And again, this is done so that people are not going to be put through the expense and aggravation of having to defend themselves on cases that they just lack merit. Many times, people who are complaining about attorneys are crazy or unreasonable. Bad blood is developed between the attorney and the client. Often, if there's a problem, a legitimate problem between the attorney and the client, it has nothing to do with the rules of professional conduct. Let's say, for example, it's a fee dispute, okay? Well, assuming that the fee was otherwise reasonable, there's a mechanism set up for adjudicating fee disputes, the fee arbitration process. That has nothing to do with the RPC. So what the secretary typically would do would say, no, this is not an ethics issue, and divert it over and send it over to the proper body that would handle that type of situation. Many times there'll be very sincere complaints about how an attorney acted in a particular instance, but it's just none of that constitutes a violation of the rules of professional conduct. As a result, there is no ethics violation. And then, of course, you have people who are just crazy. Well, did anybody in here ever represent a crazy client? No, I didn't think so. But there are people, take my word for it, there's clients out there that are crazy. You never had a crazy one, did you, Mike? No. I didn't think so. But you get clients that are really kind of out of their minds, and they say all kinds of wacky stuff, and the secretaries are able to get rid of that type of stuff. So if a complaint comes in initially and the secretary thinks there might be some merit to it, they'll contact the attorney who's in question and ask that individual to kind of respond to it in writing, provide his side of the story, and then the secretary can further make a determination whether or not this has any merit to it. And you have an obligation, affirmatively, to cooperate at this stage in the proceedings. But be mindful that all this is confidential. None of this is for public consumption at all. The idea being that if there is no merit to it, it can be dismissed without anybody ever finding out about it, doesn't become public information, and everybody's reputation is protected. It is during this time period that you can make an application for diversion. And there's an acknowledgement by the attorney that, I probably did violate one of the RPCs. The key is that the parties have to agree, whoever the presenter is and defense attorney, that if the matter did get tried, that the worst that the attorney would be looking at in terms of discipline would be an admonition, okay? And if everybody can agree to that, you're basically going to be okay. You'll be able to qualify for diversion. So you basically have the nature of the RPC, the time issue, you got to do it before it goes to formal complaint, and finally that the ultimate discipline you would get would be an admonition. Now, this is probably the hardest part, because who's to say what you would have gotten? Well, the way you do this is you'd look at precedent out there for people who've done similar RPC violations. You try to find cases where their people have done the same type of nonsense or close to it. And then you say, there might be 5 cases out there, 3 of them wound up with reprimands, 2 of them wound up with admonitions, or vice versa. But you make the pitch. And many times I found that it's, the old adage that it's not the dog in the fight, it's the fight in the dog. And you may have an adversary who really just is kind of lukewarm about going forward with the case and is looking for an excuse to kind of dump it. And if you can make a halfway decent argument that it's an admonition case, even though it really technically, if somebody wanted to push the matter, could wind up being a reprimand case, that will offer them or afford them an opportunity to divert the case out of the attorney disciplinary system. So it's really a question of advocacy more than anything else, putting that together and making the pitch that this is an admonition case. Now, once you've met all these criteria, the case will then be diverted. And typically, like PTI, they'll do something that's going to rehabilitate the attorney or educate the attorney so this type of thing is not going to occur in the future. It depends on what the underlying problem is. If it's an accounting issue, like say with the trust account, they would have them take a class or course on trust accounting procedures. If there's it's as a result of ignorance in terms of what the requirements of the RPCs are, they'll have the guy take an RPC course. Many times it may be the result of depression, alcoholism, drug abuse, things of that nature, and these are medical issues more than anything else, so they'll have the attorney get involved in some type of counseling, psychiatric, alcoholism counseling, whatever it may be, to address whatever the problem was that triggered this RPC violation. Normally they'll give you anywhere from 6 months to a year to kind of get it squared away, and if you can successfully do that, the complaint winds up getting dismissed. There's no such thing as an expungement in the attorney disciplinary system. It just kind of goes away. It's out there, in your record, but it's not available to anybody in the public. And the only purpose really for keeping it would be that if you want to get diverted again, to make sure that there's been 5 years since your previous diversion. That really is the only purpose that it would serve. Okay, so kind of keep that in the back of your mind, that the best the best result is no result at all, either by demonstrating that there is no RPC violation early on in the proceedings or getting a diversion. Now, once the investigation, though, has gone through the preliminary stages from an inquiry to a grievance, the Secretary is satisfied that there's sufficient evidence out there to provide, I guess, what would be the functional equivalent of probable cause to believe that you violated an RPC, the Secretary will promulgate a formal complaint. Now, once a complaint has been released, the entire system is above board and, most importantly, public, meaning that every aspect of it is open to review by the press, that the public can attend any hearings that take place. There's no such thing as, there's no secretive aspect to it at all. It's all done above board and in public, and that's just the policy decision that the court adopted a number of years ago. So we have public discipline in New Jersey in every way, shape, or form. And it's interesting because sometimes you get these cases heard and you'll have a number of political enemies and aggrieved people showing up and just kind of sitting in the audience and glaring at the attorney. I've been through those things. I've actually been with them up in before the Supreme Court where they had to bring in extra state police just for security purposes. You get those cases a lot out of Bergen County where you have these little tiny towns where they're like fiefdoms and the politics is just totally cutthroat and deadly, and they play for keeps in Bergen County. It's almost as bad as Hudson County, okay? All right. So we have a public disciplinary system once the case goes to formal complaint, all right? Thereafter, everything's open for consumption, so to speak. On admonitions, you can look at it as a warning that you've been warned that your conduct was inappropriate and basically don't do it again. What's interesting about admonitions is that they are non-reportable disciplinary options in the sense that there is no published decision that reflects that you've gotten an admonition anywhere. Although of course it's public and all that, there's nothing in New Jersey reports that would say anything about you getting an admonition. It would exist basically in two places. There will be a DRB opinion which made the recommendation as to the admonition, and there'll be in your file at the Supreme Court, your attorney file, there'll be a record that you had an admonition, okay? It's important because admonitions, of course, although they're not reportable, the court would take that into consideration if in the future you kind of screw up and they're going to discipline you a second or third or fourth time. The Supreme Court utilizes this idea of progressive discipline so that each time you come in, they give you an enhanced discipline to kind of like keep hammering into your head that this is the kind of conduct that can't be tolerated, and at some point, you're going to kind of get the idea that you can't be doing this type of stuff. So that's the key with an admonition. Now, every other level of discipline beyond admonition is reportable, meaning that there will be a citation to New Jersey reports that will have your name on it. Okay, so at 207, New Jersey, page 137, there'll be a citation in re Schmo. Okay, but in re Schmo, generally speaking, will have zero value to anybody because all it's going to be is a disciplinary order. It will have your name, it'll have what the RPC violations were, and then what the discipline is. That's it. It has zero utility to anybody in the world from a scholarship standpoint. It's just the public component of the discipline that was imposed. And there are hundreds and hundreds and hundreds of these things for all manner of RPC violation. But it's going to be out there. Now, this is going to be a problem from a research standpoint, which I'll talk to you about momentarily, but I just want everybody to understand that every level of discipline is going to result in a report to New Jersey reports, okay? The reprimand is a expression by the court of their condemnation for your conduct on this particular occasion. The next level of discipline is the censure. And I think the censure initially can be looked at as really an enhanced sense of opprobrium. The court views your misconduct. But I don't know that members of the bench and the bar really can make a distinction between a reprimand and a censure. Certainly no lay people can do that. To them it's all the same thing. And people who are not in the biz, they don't really they don't understand the distinction between a censure and a reprimand. They're both pretty bad, I guess. But if you're dealing with this type of stuff, especially when you're dealing with a young attorney, you've got to do everything possible to tamp down the initial discipline your client gets and fight really hard for a reprimand. You take a difference between somebody who's young and somebody who's like Mike and me, okay? If you and I screw up, it really doesn't matter all that much whether we get a censure or a reprimand, because they're never going to catch us again. We're too old. If we screwed up, it would be as a result of something that's unlikely to recur. You know, it's just a one-time deal. We had a bad day or whatever, and everybody's going to move on. Highly unlikely. When you're dealing with somebody who's been out practicing, though, for a relatively short period of time, especially when you're dealing with a solo practitioner, the likelihood of this guy screwing up again in the future is extremely high. So when you have those types of cases, you've got to really fight initially to get the lowest possible level of discipline, because when he inevitably comes back, they're going to ramp up the amount of the discipline. And I've seen cases where you can go initially get a reprimand. You might even get a reprimand the next time, or a censure, but I've never seen anybody get 2 censures in a row, okay? If you get a censure initially the first time out, when you come back 4 years later, 5 years later, whatever it may be, they're going to suspend you from practice. It just goes with the territory of this idea of a progressive discipline. So again, when you're dealing with somebody that you think, you know, this guy's going to be back here someday because he just doesn't get it, he doesn't have the wherewithal, he doesn't have the skill set to be able to take care of himself, you've got to try to kind of look at this strategically and really fight hard for reprimand the first time through, if you can get it, okay? Apart from that, though, I don't know that there's really any palpable difference between a censure and a reprimand. Where it comes up is, again, in subsequent disciplinary efforts. Now, the next stop up the food chain is the suspension from practice. I want to commend to you, which is probably the most important rule in all the disciplinary rules, is Rule 1:20-20. If you represent somebody who's going to be subject to a suspension, please, please, please sit down with your client and go through Rule 1:20-20 line by line. 1:20-20 sets forth the steps that attorneys have to take once they have been suspended for practice for any period of time. And if it's something for a period more than 3 months, there are some very painstaking steps that you have to take. Your suspension will not be deemed to have begun until you've completed the steps in Rule 1:20-20. For suspensions that are longer than 3 months, it's going to involve, for example, removing your name from the phone book, taking your sign down from your office door, contacting every single one of your clients and explaining to them that you've been suspended from practice and they've got to seek other counsel, taking your name out of the yellow pages and taking your website down. And they have a whole laundry list of things you've got to do under those circumstances. And then certifying to that and providing proof that you've done it to the Office of Attorney Ethics. Your suspension doesn't begin to run until you've complied with 1:20-20. That rule also has the procedures you go through to get readmitted to practice after you've served out your the determinate term of your suspension. So please go down, and also another thing that's in 1:20-20 is the restrictions you have in terms of your ability to express legal opinions, become involved in any aspect of the practice of law, which basically you can't do anything. But there are certain restrictions that are placed upon you in your personal and professional life as a result of a suspension from the practice of law. And again, you've got to comply with them under Rule 1:20-20. Now, when a suspension from practice occurs in New Jersey, 3 months is the minimum period that the Supreme Court will ever impose. There is no suspension time less than 3 months. This is an administrative determination that was made by the court a long time ago. I had a conversation with Justice Handler about it once, and I don't remember why he told me it was 3 months. I'm going to be seeing him again in the next month or so, and I'll try to remember to ask him about it. And this has become significant, especially when you're dealing with matters of reciprocal discipline. If your guy's admitted to the bar in some other jurisdiction and he's subject to discipline in that jurisdiction, a suspension from practice in that other jurisdiction, let's say for 30 days, would result in a 90-day suspension in New Jersey, because we don't recognize a suspension of less than 90 days. So usually when you have reciprocal discipline in jurisdiction A, you'll get the same thing in New Jersey, except that if the suspension is less than 90 days, you'd get 90 days. If you're talking about a suspension as a matter of discipline for your client, you got to be able to say to your client, you know, you're going to be suspended. 90-day suspension is the minimum you should get. And by the way, for what you did, that would be a gift. You got to say that to your clients sometimes. You get them like thinking realistically. I just have to tell you a quick story about this. I was in the Supreme Court one day getting ready to argue a case, and there was a guy in front of me, and I'll never forget, I don't want to embarrass anybody, but the guy had the same name as a very prestigious personal injury attorney in my county, okay? Identical name, spelled the same, everything the same, except it wasn't this guy. It was a different guy with the same name, all right? This guy's from North Jersey, and my guy's from Mercer County. And he got himself involved in a scam whereby he was doing what they call equity stripping, all right? And I'm not quite sure how it works, but it was some kind of crazy mortgage scam that he was running with some other guys. And it was all during this 2008 crisis that we had in our country, you know, where the financial markets collapsed. And the court, you could see from their body language and their questioning and their general attitude, they were furious with this guy because he took advantage of people that really were vulnerable and basically robbed them. And had incorrect and fraudulent entries on HUD forms. You know, how he wound up why he didn't get prosecuted federally is beyond me. And Justice Albin basically was prepared to accuse him of causing the financial collapse of the United States. I mean, that's really how serious the court was taking this. So the justices took a little break, and we went outside, and the guy knew me, he knew of me, so he said, well, how do you think I'm doing? I said, well, I'm not your lawyer. Talk to your lawyer. He says, no, I want you to tell me. I said, I'm not telling you shit until your lawyer says it's okay. So he went over, and the attorney was really kind of shaky about doing this stuff. So I said, listen, what did they offer you before? And they said, well, they offered me a 3-month suspension. I said, you go in there and you jump all over that, and you do it right now before they change their minds. That's a gift. You can see where this is going, and it's going bad. It's a parking ticket. Suck it up. Take the 3-month suspension and move on with your life. Don't become the poster boy for equity stripping cases where they're going to suspend you for 3 years or disbar you or something like that to make an example of you. Because there's plenty of other guys out there who are doing the same thing you were. They just haven't been caught yet. It's just a matter of time before they get caught. So they went in and did it. I didn't see what happened, but I saw that they ultimately did get a 3-month suspension. So, I mean, you got to look at these things sometimes in the context of what the guy did and what he really deserves versus what they're offering. And 3 months is, you know, it's a gift sometimes. But that's the minimum period of suspension that you're going to get. The maximum period of suspension they'll give you is going to be 5 years. And again, this is a administrative determination that was made by the court. This one, I remember Justice Handler told me that the justices felt that if somebody's been out of practice for 5 years, they've just been out of the game for too long, and it's going to be impossible for them to ever get caught up in terms of the development of the law and procedure and things like that. I don't agree with them at all, but that was the philosophy. So they've arbitrarily picked 5 years as the outward limit of suspension terms. Okay? I'm not suggesting to you that you can get yourself suspensions that are longer than that. For example, let's say the Supreme Court suspends you on some type of emergent basis, and you're out there, you're suspended temporarily, and the suspension goes on for a couple of years, and then they hear your case, and they decide they're going to suspend you on the merits for 4 more years, okay? And they run that consecutive to the 2 years you were there temporarily suspended. You don't get any credit for time served, typically, in these cases. So, as a net result, you could wind up serving a 6-year suspension. That's a rare occurrence. It has happened in the past, but typically they cap out the suspensions at 5 years. Now, disbarment in New Jersey is a death penalty. If you're not admitted to another state and you get disbarred in New Jersey, you have no ability to ever practice law anywhere in the United States again. Okay, no state will admit you. New Jersey certainly will not admit you again. There is no mechanism in New Jersey to ever be readmitted to the bar after you've been disbarred. Okay. Now, in having that policy, which is a matter of long-standing in our state, New Jersey is in an extremely tiny minority of states in the United States. There are only 3 other states that have the same rule as New Jersey does. Those states are Ohio, Indiana, and Oregon. I have to tell you, by the way, if you stop to think about it for a second, Oregon is the only other state in the United States that you can't pump your own gas. There's a law review article there. I just haven't quite figured out what the connection is, but I'm working on it, okay? When I find it, I'm going to write a law review article on it. So you can see that apart from these 4 states, you have 46 other jurisdictions where there is a procedure that allows attorneys who have been disbarred to go back and make an application for readmission. I saw this before. This is many, many years ago. I wasn't aware of this. I was watching the impeachment proceedings for Alcee Hastings, who was a federal district court judge. I think it was in Nevada or something. And he wound up getting impeached and thrown out because of some criminal conviction and was disbarred. And then years later, I see he's elected to Congress because they didn't bar him from future federal office as part of his procedures, and he was readmitted to the bar. And I said, how could that be? The guy got disbarred, you know? But it turns out the vast majority of states have a procedure for reconsideration of your law license after passage of time, typically 5 years. 5 years seems to be the rule around the country. I am not suggesting to you for 1 second that this is something that happens automatically. It just is a possibility. It's up to the individual attorney to appear before his Supreme Court and provide evidence to suggest that you're rehabilitated, there's no possibility of you engaging in misconduct in the future, and the public is not in any way threatened by readmitting you to the bar. Now, that's perfectly fine, but we don't have that in our state. It's a very harsh rule in our state. Now, this is controversial, and there are certain interest groups out there who have sought to have it taken away for quite a long time. The most significant player in that effort was the State Bar Association. And at the end of the tenure of Chief Justice Willents, after his passing in 1996, our court was then led by Chief Justice Poritz. And I think the State Bar Association thought that that was the moment, that was their time to kind of make the pitch here, because they had a really good working relationship with her professionally over the years. They knew her, she knew them, they just got along famously. So the State Bar really kind of made a major, major push at that point to the court to have them get rid of this lifetime ban that we have in New Jersey now and come up with a mechanism for reconsideration after 5 years like so many of the other states do. The court did, in fact, consider it and rejected it. I don't know what went on behind closed doors, but again, they were not going to give short shrift to the State Bar Association. So as a compromise, the court created the option of the so-called indeterminate suspension. Now, by coincidence, the court published a case last week involving an attorney by the name of Neil Cohen, who had been a politician, was prosecuted, a very powerful politician. I guess he was in the assembly, but got himself involved in a kiddie porn situation, was prosecuted on a state basis, and went to prison, and made a pitch to maintain his license, and the court determined to impose an indeterminate suspension on him. Did you guys see that in the Law Journal? Yeah. No. Now, the indeterminate suspension, and the court published his case for 2 reasons. Number one, and I think they're incorrect in this, they're saying that this is the first time they've used an indeterminate suspension. I don't believe that's true. I think they have used it in the past. I think their law clerks missed it, but I'm pretty sure that they have. I'm going to research that this weekend. The second thing is, so they wanted to say that this is the first time they've used an indeterminate suspension, but they also wanted to announce a new rule of law that they're going to take a very harsh look at these kiddie porn cases because, although they don't say it in their opinion, I know what they're talking about. There had been a wide range of disciplinary outcomes in kiddie porn cases. And normally the distinction was who knocks on your door at 6 o'clock in the morning, okay, with a search warrant. Is it the FBI or is it the Attorney General's office? Is it the FBI or the state police, okay? If it's the FBI, forget about it, okay? You're going to be disbarred. There's just no doubt about it. Because the federal prison sentences associated with kiddie porn cases are so draconian, they're so long, that there's just no way the court's going to allow you to continue to practice law. I had a guy represented one time The guy, there was a long delay between the time that the FBI arrested him and the time he ultimately got sentenced. And he put so much effort in. In fact, the FBI agent said, listen, buddy, you're sick, get help. And based upon that, he did get help and spent the next 3 years getting himself rehabilitated. And to the point where when he showed up in federal court to get himself sentenced, even the district court judge said, you know, I find that you're totally rehabilitated. Unfortunately, my hands are tied because federal law says you got to get X. So I think he wound up getting 8 years in federal prison. So when I argued his case before the Supreme Court, you know, I pointed out that everybody, including the judge who sentenced him, knows the guy's rehabilitated. There's no downside to considering this guy for readmission later on, given indeterminate suspension. And what I wasn't aware at the time was that there's an unwritten rule among the justices that when an attorney gets a jail sentence, there's a certain point of no return where if the jail sentence is beyond point X, they will just disbar you. And I think it has to do with their perception of the confidence of the public. A guy who serves a jail sentence of, say, 18 months, I think the public, or they think the public, will accept this person back as an attorney. But when you're talking about people who are serving jail terms of 2, 3, 4, 5 years and beyond, the public is just not going to accept them back. The jail sentence is too long. Now, this again this isn't written anywhere. I'm just kind of telling you this from having studied all of their decisions. Maybe I'll be able to talk to Justice Albin someday and say, where's the dividing line between this? And maybe he'll tell me, I don't know, or maybe he won't. But I'm pretty sure that that's the way these things go. So the indeterminate suspension is reserved for people who, the way the court describes it is, are on the cusp of disbarment. And it looks like it's something that's been used, apart from my own research to find out, from the court's perspective, this is the first time they've ever used it, although it's been on the books for since the era of Justice Porritz. From an advocacy standpoint, it presents a very difficult challenge for New Jersey attorneys. Okay, and let me tell you why. Let's just pick a state at random. What's a stupid state?
Mississippi.
All right, Mississippi. Can't get any stupider than Mississippi, right? So you're representing a guy from Philadelphia, okay? And this guy's going to be disbarred today, okay? So where is your guy today? What's he doing? And the answer is, it doesn't matter. He could be in prison. He could be home taking a nap. He could be drunk in the gutter. It's utterly and totally irrelevant where your guy is today, okay? He's going to be disbarred, and that's it. Fine, case is over. Except, starting today, he has 5 years to start taking the necessary steps to rehabilitate himself. First thing he should do is move out of Philadelphia and get out of Biloxi, but that's another issue, okay? Put together a package to show that he's addressed whatever those issues were that got him disbarred in the first place, and made his amends with society to the extent, made rehabilitation to clients, done volunteer work, you know, all the things that you have to do to put a package together. And then 5 years, 6 years, 7 years, whenever he's ready, go make your pitch to the Supreme Court of Mississippi. And then they'll either say yes or no, or come back in another year, you know. But the prospect of you getting readmitted is out there, okay? In New Jersey, it's exactly the opposite. You've got to take a guy who's at the lowest point in his life, who may be in prison, who may be in the throes of some horrible depression or alcoholism or drug abuse or something like that. And you've got to be able to argue before the Supreme Court that there is a shred of hope. There's a little tiny sliver of light in this guy's life. There's hope to believe that he's going to utilize the next 5 years to rehabilitate himself. Because if you can't show that to the court, there's no point in getting an indeterminate suspension term. You just disbar the guy and that's the end of it. If he's not going to be able to rehabilitate himself at some point in the future, then what are we talking about here, okay? But that's a very big challenge to attorneys who are advocates in these cases, to kind of find that in your client, A, and B, be able to persuade the court that there does exist hope for this person. This has been my biggest problem in terms of kind of pitching these things to the court in the cases that I've been involved in, which is probably why, according to them, that the Neil Cohen is the first indeterminate suspension case. It's just a very, very difficult challenge for New Jersey attorneys. As time goes on, the composition of the court changes. It may be that they'll relent on this and kind of conform the procedure to the rest of the country, but for now we're stuck with the indeterminate suspension and all its limitations. Now remember, the indeterminate suspension has a 5-year minimum term. So you'd have to be suspended for a minimum period of 5 years, and then the suspension just continues until such time as the court is satisfied that you're not a threat to the public anymore and that you're completely rehabilitated. You just can't make that pitch until the 5-year period has expired. So in that sense, it's somewhat similar to the other states, but you can see this is something that's been used sparingly and in the rarest of circumstances, at least through now. Okay? So these are the levels of discipline that are available for individuals who get themselves jammed up. And you know, many times you can work these cases out with your adversary ahead of time. You just have to come up with a reasonable disposition on the case, because all these things have to be approved by the disciplinary review board. So typically, if you have a guy you're dealing with, and the two of you have decided that these are the RPCs that were violated, you can stipulate to that. There's a factual basis to believe that you violated those RPCs. And then you have a joint recommendation for discipline, 30 days, 60 days, whatever it is. Normally, the disciplinary review board will go along with it, provided they think it's reasonable. And in order to show them that it's reasonable, you have to go to other cases where the same type of conduct or misconduct has occurred, and you show precedents where a 3-month suspension, say, for example, has been deemed to be an appropriate sanction for people who did similar type conduct. This is a very, very, very heavily laden precedent process. Precedent has a lot to do with persuading them in these circumstances. There may be occasions, though, where you and your adversary have agreed on a particular level of discipline, and the DRB doesn't want to buy into it, okay? They jump all over it, and they'll recommend something which is much, much stronger to the Supreme Court. I've had that happen to me also. I have to suggest to you that that's something that's pretty rare, that your guy would have to have done something really egregious or have gotten a recommendation for discipline which is wildly disproportionate to the harm that he did before something like that would happen. Most of the time, if you come up with a reasonable disposition that there's a basis for it in the published case law, you should be okay. And that's always the best way to handle these things, is to try to come to an agreement about these are the RPCs that are violated. This is what we both think is the appropriate level of discipline. Okay? All right. Now let's talk about research for a second. Okay? And this kind of dovetails with the idea I was talking to you about a moment ago about the importance of precedent in these types of cases. Both the DRB and the Supreme Court, when they figure out what they're going to do, they look at the individual actions of the attorney, they see who was harmed, what mitigating factors there are, but one of the things they really count on is how have we treated these types of cases in the past? What have we done previously? Because they want predictability to be built into the system, so everybody kind of knows what you're getting yourself into. They don't want wildly fluctuating levels of discipline, they want consistency. The first volume of New Jersey Reports was published in 1949, hard on the adoption of the 1947 Constitution. And in Volume 1 of New Jersey Reports, there are disciplinary cases. The Supreme Court undertook their constitutional obligations right away and started publishing disciplinary decisions. And over the next 42, 43, 44 years, the court regularly published disciplinary decisions. So there are many hundreds, if not thousands, of disciplinary decisions that came about during those decades, all right? So you have an enormously vast body of law that you can refer to when looking up Supreme Court decisions dealing with discrete disciplinary issues. They're out there, okay? In the 90s, the number of published disciplinary decisions began to dwindle, all right? And there's two reasons for that, I think. One of them, I think, is somewhat apocryphal, but it may have some truth to it, that there were complaints from some of the big shot law firms in North Jersey and Roseland, those areas, about the cost and size of New Jersey Reports, that it wasn't worth the money that people were paying for it. Again, this is a pre-internet era And it was all filled up with disciplinary decisions. So if there was a 600 or 700 page New Jersey reports, half of it would be disciplinary decisions that nobody cares about, all right? And that was driving up the costs and diluting the quality of New Jersey reports. The other part of it, I think, is just that it was just too much work for the court. It's just too much research, too much resources devoted to dealing with these disciplinary cases. Okay, they're really, in the grand scheme of things, not as important as some of the other issues that the court has to deal with and wrestle with. Okay, the disciplinary review board was already out there, and there's no sense in duplicating the work of the disciplinary review board. So the court made a determination that they were just going to let the DRB do most of the grunt work, so to speak, and I don't mean anything disrespectful about that, but just, writing the cases up, doing the research, and publishing these things and making disciplinary recommendations, subject to the court's final imposition of discipline by way of a disciplinary order. So two things came out of this, both of which are extremely significant. Number one, we don't get written Supreme Court disciplinary decisions anymore unless the court has a message they wish to convey to the bench, bar, and public. In this year, there have been 2 published disciplinary cases, and in each instance, the court had something to say. Now, what they have to say sometimes is retarded, but they had something to say. And I'll give you an example of both of these things. The Cohen case that they just published a week or so ago, again, was intended to highlight that this is the first indeterminate suspension they imposed, but more to the point, to send a message to the bench and bar that they're going to treat kiddie porn cases much more seriously in the future. In the past, typically the suspensions on kiddie porn cases that were prosecuted on a state level were 6-month suspensions. And because what happens is these kiddie porn guys, they get indicted 2nd degree, the case pleads down to 4th degree, and they get probation or PTI or something like that. And the sad thing is, you take exactly the same circumstances, same guy, same everything, but it was done in the federal system, the guy would be in jail for decades, literally for decades. But the New Jersey, New Jersey prosecutions are not the same. They don't look at them the same. And you might have situations too. I mean, you have guys with all kinds of aggravating factors. One case involving a guy who's a deputy attorney general, and he's doing this stuff at work on a state computer, looking at all these images and downloading them and all this. And he winds up either getting PTI or some 4th degree endangerment charge, 6-month suspension. So when you look at the cases, the level of discipline in the state was actually very, very minor. The disbarment cases were typically associated with cases that were prosecuted federally. Same misconduct, identical misconduct, just different prosecuting agencies. And I think the court wanted to kind of put an end to this and have some uniformity with the way they're going to treat kiddie porn cases because of the harm that's visited upon children. So I wouldn't be surprised if they just start disbarring people in the future or giving them these indeterminate suspensions when there's been a significant rehabilitation. This is a case the court published in order to set forth a brand new rule of law, okay? And we have to get to this rule of law at some point, so let me just kind of tell you the story now, and then it'll make sense to you. The attitude of the New Jersey Supreme Court is that disciplinary cases are highly fact-sensitive. And the precedents involved in it, the individual circumstances of the attorney, the aggravating factors, the mitigating factors, all these things are unique in every single case. Therefore, we're going to judge each case on its merits based upon the facts, the law, the precedent, etc. Okay? We only have one exception to that, and that is cases involving the knowing misappropriation of trust funds. This is the so-called Wilson Rule. The Wilson Rule comes out of the 1979 decision in Ray Wilson from our Supreme Court, the first major decision written by the late Chief Justice Willents. And the Chief Justice, nobody can accuse him of being a shrinking violet. He had extremely strong opinions on a whole variety of things and used the power of the judiciary to impose his will and his idea of how things should be, not only on the judiciary, but also in terms of social policy to the extent that he could in the decisions that he wrote. he had an enormous impact in the development of our jurisprudence. Just as a sidelight, in New Jersey, our whole disciplinary system is modeled on his view, administratively and substantively. For example, the Office of Attorney Ethics did not exist when he became Chief Justice in 1979. This is solely a creation of the Chief Justice. He dreamed the whole thing up, bypassed the legislature, bypassed the executive branch of government, and just imposed it on the attorneys and the citizens of New Jersey. He was able to do this because he didn't need any money to do it. There was no taxpayer money that went into the formation of the Office of Attorney Ethics at all. It's completely self-funded, either through contributions by the attorneys when you do your annual attorney, with the money you pay every year in April, okay? Part of that goes to fund the Office of Attorney Ethics. And the people who are subject to discipline are also required to pay. You have to pay for the cost of your own prosecution and transcript fees and things like that. He modeled the Office of Attorney Ethics on the Attorney General of New Jersey. So just as the Attorney General constitutionally is the chief law enforcement officer of our state, the director of the Office of Attorney Ethics is the chief disciplinary officer of the state of New Jersey. Just as the Attorney General has supervisory authority over the 21 county prosecutors, the Office of Attorney Ethics has supervisory authority over the district ethics committees throughout the state. I think there might be 18 or 19 of them around the state. Every county has at least one. A couple of counties, like Essex County, they have two because they have so many attorneys in that vicinage. The Office of Attorney Ethics will be responsible not only for oversight, but they take on their own investigations and prosecutions in cases that involve multi-jurisdictional issues, that involve complexity, in issues where the local district ethics committee is not moving the case forward in a timely basis. They're delaying or just not competently handling it. They will also go in on emergency applications before the Supreme Court for suspensions, temporary suspensions of individuals who either are indicted for serious crimes or charged with serious crimes or are not cooperating with an ongoing investigation, or who pose an imminent threat to the public or to a client. Those are situations where the Office of Attorney Ethics will go in on an emergent basis. So supervisory, plus they do their own cases, and their resources are available to help out on the district ethics level if they have to. The chief also, in 1984, very close to the time that they established the Office of Attorney Ethics, made the determination to adopt the Rules of Professional Conduct. Okay, again, this is something that the chief pushed for. He felt that that was a modern code, and he wanted to conform New Jersey disciplinary law to the disciplinary law for the rest of the country. So just like the New Jersey Rules of Evidence mirror the federal Rules of Evidence, and the Mississippi Rules of Evidence for that matter, all the same numbers. If I say 401, you know, in New Jersey, it's the same rule every place else because of the uniformity of the numbering system. The RPCs are the same. These are developed by the ABA out of Chicago, and everybody adopts them. They all have the same numbers. So if I talk about RPC 3.1 in New Jersey, it's the same thing in Mississippi or any place else that has the RPCs, which I dare say is most of the country. Parenthetically, I have to tell you that it's not enough to just look at an RPC. You've got to look to see how it's been construed and how it's applied in New Jersey, because New Jersey may have a unique view of a particular RPC, which is not shared by other jurisdictions in the country. But having said that, though, these are just two kind of examples of the chief putting his mark on policy issues, in this case substantive or procedural issues. The substantive issue that the chief addressed in his first major published decision ever came about at In re Wilson. The chief was very dedicated to the judicial process, obviously, but also to the idea of confidence of the public in the integrity of the bench and bar. And he felt that this is based upon an absolute trust that clients have with their attorneys. And he felt that the worst thing that an attorney could do would be to take money from a client, steal money from a client. There's no sin worse than an attorney could commit, and nothing more destructive or corrosive to the trust that has to exist between attorneys and clients in order for the entire system to work. Clients walk into attorneys' offices and turn over huge amounts of money to them, perfect strangers, and they do so typically for convenience, because of necessity, or whatever it may be, but they do so without giving any second guess, confident that the money is going to be utilized for the purpose for which it's been given to the attorney. If the public loses that level of trust and confidence in the bar, the whole system is going to collapse. It was just something that he felt very, very strongly about, and as the chief, he could put his mark on it. Now, you should know, and this is explored really in pretty good detail in the Wilson case, that was not something that was, this was a novel concept, because thefts from attorney trust accounts previously had not resulted in disbarment automatically. It was pretty much a 50-50 proposition. 50% of the time, the attorneys would be disbarred, and the other 50% of the time, nothing would happen to them. All right, I mean, they would get some level of discipline, but nothing significant. Factors such as the political power associated with the firm, the position of this guy in his stature in the public as a lawyer, the fact that he made restitution to the client, the fact that nobody ever missed the money, in other words, he took it and then replaced it before anybody was hurt. All of these extraneous factors kind of went into the mix to determine whether or not the nature of the discipline. The opinion in Wilson makes a clean break with the past. It's a clean break with the past in the sense that the chief says, we don't care about any of these factors. We don't care about restitution. We don't care how powerful you are. We don't care where you are politically. We don't care about how important your firm is. We don't care about what a great lawyer you've been for the last 45 years. We don't care that nobody ever missed the money, that nobody was hurt. We don't care. If you do the following things, you're going to be disbarred 100% of the time. That is, you take money from the trust account knowingly that belongs to a client, and you do it without the client's permission. If you meet those three criteria, and that's proved by clear and convincing evidence, you will be disbarred. There are no mitigating factors that you can advance that will help you avoid that outcome. It's going to happen in every single case. They use the words, this will be the result almost invariably, but I have to tell you, in the 35 years since the Wilson decision came out, there has never, and I mean never, been a case where someone has gotten anything less than disbarment in a Wilson situation, okay? Now, I want to tell you a little story about it, and this is, again, it only involves me to the extent that I was a witness. I was there that day. I was sitting in Supreme Court one day, minding my own business, getting ready to argue some idiotic case, and there was a man there before me. I don't know him. I think he might be from Union County. I just don't know the guy. He came to one of my classes once, and we spoke a little bit. I don't remember his name. He's a nice enough guy. And he has an attorney by the name of Jerry Tsai, T-S-A-I, that he's representing. And Tsai had been accused of a Wilson violation. He was basically running a scam out of his trust account where he would use it as a revolving charge card. He would take money out, pay personal bills, law firm expenses, things like that. And then a week or two later, he put the money back in, and then, when he got short again, he would take the money out, spend it, and then put it back in. And there was no evidence that any client had ever been injured by this, but again, this meets the definition of a knowing misappropriation. So I watched him up there trying to make the best argument he could for his client. He's looking for an indeterminate suspension or something other than a disbarment. And the Chief Justice Rabner, who's got to be one of the sweetest, nicest, kindest gentlemen that you've ever seen, just amazing judicial temperament, and just kind and nice to everybody, very polite. He wanted to make sure that the attorney had got his full remarks in and said everything he had to say, that he didn't leave anything on the table. He's gotten it all out. And the reason the chief was doing this, because he could see through the corner of his eye that Justice Rivera Soto was kind of champing at the bit to get involved in this. And basically, again, I'm going to paraphrase him. Justice Rivera Soto says, let me ask you a couple questions. Let's kind of cut to the chase here. Did your guy take the money out of the trust account? Well, I guess so. And did he do it knowingly? Well, I guess so, technically. And did he have his client's permission? Well, technically not. He said, well, our hands are tied. This is a Wilson violation. Our hands are tied. And when Justice Rivera Soto said that, I thought to myself, that's what an extraordinary thing to say. What do you mean your hands are tied? You're the Supreme Court. You can untie your own hands. You created this rule in the first place. If you wanted to deviate from it, you can. You know, as an academic, it's important for me to kind of think these things through so I can write about them intelligently, and it bothered me what he said. I couldn't figure out what he meant. I thought about it for a couple of days, and suddenly it occurred to me what he was saying. What he's saying was that the rule in Wilson is institutionalized, that neither I nor any other cabal of justices is ever going to change this. We have had almost 500 attorneys disbarred over whatever number of years it had been as a result of Wilson violations, many of whom just gave up the ghost and said, I can't successfully defend myself against this, and I'm going to consent to my own disbarment. So Wilson is institutionalized. It's as much of the Supreme Court and the rules of the Supreme Court and the procedure of the Supreme Court as is the bench and the lectern in that room. It's not going to change, ever. Okay? Nobody's going to make a difference in these types of things. Can we take a look at the argument on this? Just take a couple seconds to take a look at the argument in this side case. You guys will see what I'm saying.
But he always replenished it to cause no problem. And that's why I think, on one hand, severe sanctions are necessary. You can never close your eyes to actions like this, ever. But in this particular case, I respectfully would ask you to punish him in a way that's short of disbarment.
Any questions? Mr. Advocate?
Just with my client, his right to, I'm sorry.
Sorry.
Yes,
Are you done with your preliminary statement?
Yes, sir, unless you have questions, of course.
Your client admits that he misappropriated monies out of his trust account?
Yes, misappropriated is our word, but yes.
Okay, and he also admits that he did so knowingly?
Your
You might want to look at your client as
your client shaking his head no.
No, I know that, but he and I both feel that way, but I wanted to answer in a legally significant way.
And
The only reason
mindful of the
before-
Wilson doctrine is he
Yeah, that's why I'm asking.
Yeah.
Because if it's knowing misappropriation, our hands are tied.
I absolutely understand.
I want to say just two quick stories kind of illustrate this point, both involving me. I had a guy that I was representing one time from Monmouth County who had a Wilson case. And I made the mistake of liking the client, okay? I just liked him. He was a very, very nice, likable guy. He was charismatic and just had a lot going for him. And he'd had a very successful practice, which makes sense when you're dealing with a guy who's charismatic. I mean, this just kind of, they go hand in hand. But he had a stone-cold loser of a Wilson case. And I knew what was going to happen to him, and I felt terrible about it because I liked him. You can't like your clients. You just can't. You really have to look at them clinically. So there's a young fellow in North Jersey who kind of likes me, and I'm kind of like a mentor to him. So I came up with an idea, and I called him up, and I said, you know, you've only been practicing law for a couple of years. How'd you like to argue a case before the New Jersey Supreme Court? And he, like, freaked out. He thought it was such a fantastic opportunity for him. So I introduced him to my client. They hit it off immediately, and I had him substitute in as counsel to represent this guy. And he took it very seriously and interviewed him and investigated the case. He wrote a long, involved brief. And then on the date of the oral argument, I showed up down there to kind of give him moral support, so to speak, and he went in. And it was too painful for me. I didn't go in the chambers. I couldn't stand to watch it. So he's in there. I was kind of peeking through the window every once in a while, and I could see him in there gesticulating, you know, passionately arguing his case and all that. And I'm thinking to myself, hey, you know, Mazel Tov, you know, the guy's, he's having fun in there. That's good. So they got done with the argument, and he walks out, and the kid is literally, he's like walking on a cloud. He's so exhilarated by the experience of having gone through this advocacy. And I said, well, you know, listen, I'm happy for you, you know. So we part company, and I go back to work, and about 4 o'clock in the afternoon, I get a phone call from him, and he's crying on the phone. Crying. He says, I just got the order from the Supreme Court. They disbarred my guy. How could they do it so fast? And I said to him, schmuck, they did that order 3 days ago, okay? This was not a close case. They were always going to disbar him. All they're doing is going through and giving you the the due process component. This was nothing that they had to decide. This is automatic in every one of these cases, you know. Now, the other thing I wanted to mention to you on these Wilson cases is this. Since it is inevitable that there is no defense you can raise, regardless of how skilled you are, regardless of what type of orator you are, regardless of the mitigating factors, it's going to result in disbarment. From my perspective, it is cruel to carry on a defense of a case that has no defense. You're just needlessly prolonging the agony for your client. You're wasting his money and having him expend emotional resources that are not merited, okay? My feeling is that you owe it to your client at some point to say, look, I can't help you. Nobody can help you, all right? Your case is indefensible. Now, you're not the first attorney this has ever happened to. There is a procedure that the Supreme Court has established where you can say to them, look, I can't successfully defend myself. I'm going to submit to disbarment by consent, all right? That will end the case today, stop the expenses here, and now you can move on to the next phase of your life, whatever that's going to wind up being. And many attorneys take this option, but you've really got to be honest with your client, and this is a very difficult call to make, but it's cruel to carry on a defense where there's not going to be a defense. Now, I don't want to suggest for 1 second that if you have a viable defense to raise on a Wilson case, go forward and advocate it, and stand up on your feet and make arguments, okay? For example, let's say that there was everybody agrees that there was a taking of the money, but it wasn't done knowingly. It was done because of a bookkeeping mistake or because of some negligence or recklessness by the attorney, okay? Well, Wilson is reserved for people who act knowingly, not recklessly or negligently, but knowingly. Remember I told you about the importance of fact fights before. When you're dealing with a fight and the argument is culpability, where the presenter is arguing that your client acted knowingly, and you have evidence that shows that he acted recklessly, okay? If he can't prove knowingly by clear and convincing evidence based on that definition, it's not a Wilson case. He's going to get disciplined in some way, somehow, but it's not going to be a disbarment case. So what I'm suggesting to you is you have a case that you can defend on the merits. Please do it. There's a lot at stake here. But in those instances where there is no evidence to the contrary, you really have to tell your client. The story I wanted to mention to you involved a guy who was in this situation. He had taken $50,000 out of his trust account, the proceeds from a personal injury case. He had it out for a couple of weeks, replaced it, but he got caught in a random audit and they uncovered that. So it's a Wilson case, and he made a determination after we reviewed the evidence that he didn't want to go forward with it. Now, as the attorney for someone who's going to consent to disbarment, you have certain responsibilities imposed upon you by the Supreme Court. One is that you've got to go through a painstaking and searching inquiry with your client and fill out kind of a long, involved affidavit. But you yourself have to testify or certify that you've explained to your client what it means to be disbarred in New Jersey. You know, you're never going to be able to practice law again anywhere, okay? All right, so you go through this process, and, you know, I had him sign all the paperwork, and he looked kind of jaunty, actually, and I said, you know, I'm glad to see you're taking this so well. And he says, what do you mean taking it well? Today is the happiest day of my life. I've been in hell for 28 years, okay? And that ends right now. I've got myself a CDL license, and I have air brake endorsement. I don't know why that was important, but he said he had air brake endorsement. He pulls out this CDL. He says, I got a job. I'm going to be driving a truck, a refrigerator truck, between San Francisco and Port Elizabeth, New Jersey, okay? I'm going to be out on the road. I'm going to be listening to XM satellite radio, and I'm going to turn off my phone and have a great time and enjoy seeing America. And no judges are going to be calling me up screaming at me, and no clients are going to be calling up and screaming at me, and I'm not going to have to worry about all the stuff that I've been through for the last 28 years. Law and this guy were just a bad fit. He was just one of these people who couldn't handle the private practice of law. So, you know, listen, I'm happy for the guy. He's happy. You know, I said, you know, thinking the line out of The Godfather, you know, contento tu, contenti tutti. I'm happy, you're happy, I'm happy, okay? So, I mean, I know this is a little bit counterintuitive, but you may find this with your clients, that they're really kind of happy to get it over with and move on to the next phase of their life, so to speak. But that's the ruling in Ray Wilson, all right? And you just kind of got to know this because according to the court, you know, every other case that comes before them is fact-sensitive and will be decided on its merits. The only thing we're going to automatically impose a level of discipline, which in this case is going to be disbarment, is in the Wilson cases. Now, this gets us back to the second earlier case that they published this year, which is this Camarera case. Did you find that, by the way? It's still on the Judiciary's website because it's fairly new. This is the only other case they've published this year. And it's kind of silly. It was completely unnecessary. It's something that's bothered me for a long time. I read in the case law, you know, the court repeats over and over again, these are all fact-sensitive cases. The only exception are Wilson cases where we will automatically disbar. Every other case is fact-sensitive. And I read this over and say, that's just not right. You're not, your law clerks are letting you down. That's not what your precedents say at all. Because there's another type of misconduct that always results in disbarment every single time. You've just never publicly said it, but I'm telling you this is what happens. That's bribery of a public official. Bribery of a public official, in other words, you're either receiving the money or paying the money over, 100% of the time results in disbarment. And by the way, it results in disbarment when the guy gets prosecuted criminally and gets convicted. It results in disbarment when the guy gets prosecuted criminally and gets acquitted. It doesn't matter. They disbar you anyway, okay? There's only 6 cases involving disbarment where the guy was acquitted. Acquitted at trial by a jury, they disbar him anyway, okay? So that's just a rule that they've adopted. They do it all the time. So this Camarera case that got published a short time ago, the guy was a mayor of some Hudson County place in a Hudson County town. And I forget whether he was receiving a bribe or paying it. It doesn't really make any difference. And the Supreme Court, with great sanctimony, announced that henceforth our rule is going to be, just like Wilson, that anybody who you know, is involved in bribing of a public official is going to be disbarred. Well, newsflash, it's not a new rule of law at all, but they published a decision to kind of announce this to the general public, okay? But it's nothing new under the sun, all right? But that's what they do now. They won't publish a decision unless there is a, they want to send a message out to everybody, or there's some new rule of law that they want to discuss, or some big controversies come up, or an RPC, for example, needs to be construed, okay? It's very unusual where these things come up. Every once in a while, one of the justices, usually Justice Albin, gets a bee in his bonnet about some procedural thing, and then he'll publish a case about it, okay? A few years ago, Justice Albin got very angry about people who get orders to show cause before the Supreme Court and then don't show up for their order to show cause. So he published an opinion saying that this is usually going to result in disbarment if you have an order to show cause and you don't show up. And I think the other justices were not happy about it because the following year they published another case and kind of walked that back a little bit with a guy who was 10 times guiltier than the first guy that they were talking about. So, but I mean, this is what, it's just unusual to get a case published by the Supreme Court unless you're dealing with one of these issues. Now, when we talk about precedent, since you're dealing with things that are so vitally important and there's a dearth of precedent from the Supreme Court, what are you supposed to do? Well, let me just kind of give you a couple of tricks of the trade. First of all, if the Supreme Court published 1,000 disciplinary cases over the 40-some years, of those 1,000, I'm going to tell you that 950 of them are per curiam decisions, okay? It's only when there's something really significant and they really want the public to pay attention that you get a signed opinion. Most of the time, they're per curiam. And, which is good, but if you have a case that's signed by one of the justices, that has extra impact. It has extra persuasive authority, okay? Or binding authority. And if you have something signed by the Chief Justice, now you're dealing with something that's extremely important. Equally important is to check to see whether or not there was a dissent in the case. Dissents are unusual in disciplinary cases, but when they come out, they can have enormously important consequences down the line. And I'll give you a couple of examples of that in a few moments. Even if one justice dissents, that's enough, okay? And you have to look to see what they do because you'll be able to utilize that for your own case as circumstances and times change. So what are you supposed to do? Well, obviously the starting point is going to be see whether or not the Supreme Court ever ruled on this particular issue and discussed it in a published case. That's perfectly fine. The next level down that you should be looking at would be the Disciplinary Review Board. They publish decisions in every single case. Every single case. This is a published decision by them. And the good news is that they are exhaustively researched, and they will put in every single case that has any relevance to the decision at all. I mean, they just over and over again, they will repeat every single precedent over and over and over again. So if you can find the right case, they'll do all your work for you. It'll all be in their opinions. The problem that you run into is really twofold. Number one, the opinions of the DRB aren't published anyplace. There's no book of DRB opinions. You have to find them, and they are on the judiciary's website. You have to kind of dig for them to find them, and then it's basically all it does is it provides you a link to the Rutgers University Camden Law School, and their library there is responsible for keeping the archive in a digital format of the Disciplinary Review Board decisions, which just really just PDF files, okay? I've given you on the screen here behind you the link to the Rutgers University Law School Library to get the DRB opinions. The link has a very rudimentary search engine associated with it. So if you're looking for a particular case, you'd say in re Schmo, and it'll come up with that in quotes. Or if you want to research RPC 3.1, just put in quote RPC 3.1. You'll get the phone book. I mean, you're going to get every case that ever mentioned that they have. Things get complicated because when you're reading the DRB opinion and they're citing precedent, okay, they'll say, and as we held it in Ray Smith, okay, and they'll have a citation to New Jersey Reports. But the citation to New Jersey Reports is worthless because if you go to New Jersey Reports to look it up, all it is a disciplinary order. To figure out what they're talking about, you got to go back to find their opinion in Ray Jones or Smith or whatever it is, and see what they said. And you have to look up, pretty much look it up by name, and to the extent that they give you a docket number, you may be able to find it by docket number. So don't be fooled by this. They rely on precedents and they refer to the Supreme Court, number, but it's not. That's nothing. You got to look at their case to find out what they were talking about. Okay, it's critically important because the DRB relies upon not only Supreme Court precedent, but they rely on their own precedent all the time. And I guess to the extent that the DRB recommends a certain level of discipline and then the Supreme Court adopts that, imposes that level of discipline, I guess in a way that's an imprimatur that the Supreme Court has put on the opinion of the DRB. So I guess the argument you make is that's the appropriate precedent in those types of cases. Now, there's another body that is responsible for promulgating binding opinions, and that's the ACPE, the Advisory Committee on Professional Ethics. They're probably up in the 800s now in terms of the number of opinions they have, maybe even more. Their opinions have the force and effect of law. In fact, if you can demonstrate that your client's conduct conforms to an opinion by the Advisory Committee on Professional Ethics, that constitutes a complete defense to the RPC violation. They're established by, I think it's Rule 1, Call 19. They field questions from members of the public, from members of the bench, the bar, anybody, and ask for, you give them situations and they'll come back and give you an opinion about what the appropriate approach would be from an ethical standpoint. Let me just give you an example. There's one, I was teaching it the other night, that's why it's just at the top of my head, it's opinion number 661. 661 deals with the obligation of prosecutors to refrain from requiring a stipulation of probable cause as a condition for the dismissal of matters in municipal court. So traffic offenses, DPs, petty DPs. Prosecutors are not permitted to require a stipulation as to probable cause. Now, the reason for that is because prosecutors have a unique role in the criminal justice system. They don't represent cops. They don't represent the municipality that employs them. They represent everybody in the state of New Jersey. Their function is not to seek convictions, but to do individual justice in individual cases. So by stipulating or requiring stipulations to probable cause, it's improper because, first of all, if the case has no merit, if there was no probable cause in the first place, ethically they have an obligation to dismiss it outright. Again, individual justice in individual cases. If it had no merit, you dismiss it, end of story, and you move on. But more importantly, by taking that position, you're becoming an advocate for the town and for the police officer because you immunize them from civil rights suits and things like that by stipulating that there was probable cause. So 661 discusses this issue and indicates that it's unethical for prosecutors to do this. It's bad enough for prosecutors to do it. I've seen judges do it. You know, people walking out the door, the judge will say it's an aftersight. Oh, by the way, there's stipulation of probable cause here, right? You know, it's bad for prosecutors. It's a whole lot worse for judges. You know, so.
They offer it voluntarily. What do you think?
Yeah, if people want to volunteer, that's fine. I'm not sure that it's necessary, but it shouldn't be anything that's
Completely superfluous, but a lot of people still do.
I know. It's just, if people want to do it, that's fine, but it's something that can't be required, you know, as a condition of the plea and sentence agreement. But forgetting about the substance of it, this is just a typical example of the many hundreds and hundreds of ethics situations that they would address, and they have the force and effect of law unless they've been withdrawn or modified or changed by the Supreme Court. That happens on occasion as well. The Supreme Court will go in and modify one of the. All right. So again, the Advisory Committee on Professional Ethics, their opinions are not published in any book, any place. You've got to get them out of the Rutgers University website. There is the site for or the link for that website. All right. Okay. Now, let's take a second and get into some specific RPC violations, all right? And there's a little trick to this. I want to go back to In re Wilson for a second, okay? The Wilson case, when you read it over, and you know anything about how disciplinary cases work, was going to be a disbarment case from Jump Street, okay? This is a guy who was going to be disbarred. Because not only did he steal money, but he had like a million other things that he did that were bad, okay? A ton of stuff. The guy's he was just a train wreck. And what the Supreme Court does is that they completely disregard all the other stuff that he did, and they focus just on the stealing the money from the clients, all right? But just when you look at the totality of what this guy had done, even without stealing the money from the clients, this was going to be a disbarment case. So this is a guy who just couldn't get his act together, so to speak. And this is a problem that you run into sometimes in disciplinary cases when you look at sort of analyzing the RPCs. You're not going to get a case, ever, where the only RPC you're dealing with is going to be 1.1. It doesn't happen that way. It's not in the nature of the beast, okay? One act of misconduct by an attorney typically will implicate 3, 4, or 5 different RPC violations, and they will all get charged. So when you're looking at a level of discipline, you can't look at individual RPCs in isolation. There's no such thing. You have to look at combinations of RPCs. It's like playing poker. You have different hands that are dealt, and they have different values, okay? So you might have, for example, misconduct incident X, and that's going to implicate RPC 1.1, 1.3, maybe 1.4, 8.4. You'll see how they all, they'll just come together as one big smush. And then you've got to start figuring out, when you have this combination of RPCs, you know, what is likely going to be the discipline? And remember, you have the RPCs themselves, the precedents for them. Don't forget also your client's history. You know, if he has a bad history, it's going to ramp up the discipline as opposed to he doesn't have any history at all, which would tend to keep it more civilized. Let's talk about the individual elements for RPC 1.1. There's 2 of them. The first one deals with gross negligence, gross neglect, okay? So you're not supposed to handle a matter that's been entrusted to the lawyer. In other words, you've undertaken, there's an attorney-client relationship of some kind with you where you've volunteered to undertake some type of legal work. It's such a matter that the lawyer's conduct constitutes gross negligence. Now, gross negligence is not defined. It comes through the case law, but the idea of gross negligence is really a function of harm to the client. How bad did the client get hurt in this particular case? All right? And many times, it's not necessarily a question of how badly the client was hurt, but what steps have you been able to take to mitigate the damages? Okay? Now, that's not going to excuse the RPC violation, but it will significantly affect the level of discipline. Let's take two situations. You let a statute run, okay? Your guy lost out a lot of money because you let the statute go. But what you've done, your guy, let's say his net recovery would have been $66,000, okay? You pay the guy $66,000 out of your own pocket, so he's been made whole, all right? It doesn't excuse the RPC violation, but it's going to be an extremely significant factor in determining what level of discipline. You might wind up getting a reprimand for something like that, okay? Contrast that with a guy who, you know, he undertakes the case, a lot of liability, a lot of insurance on the other side. He's an LLC. He doesn't have liability insurance like he's required to have if you're an LLC. Doesn't have malpractice insurance, and he lets the statute run. And he doesn't have the wherewithal to make restitution. So you have a client who's lost an enormous amount of money where he should have recovered it, and there's nowhere to go because the guy violated an additional RPC by not having liability insurance for an LLC. You know, that is going to be, among other things, gross negligence. All right, you've got a client who's suffered an enormous blow as a result of the idiotic behavior of the attorney. Okay, the concept of the grossness of the negligence, so to speak, is really going to be a function of the harm to the client, and then you can mitigate that by restitution or taking other steps to make the client whole again. Now, under B deals with this concept of pattern. So the first thing I want you to note is that it is not an RPC violation to engage in an isolated act of negligence. That's not a violation. By the same token, once you get yourself involved in a pattern of negligence, then that is a violation of B. Pattern is defined through the case law. Mike Amatia, who I think works for the Public Defender's Office now, had a case involving an issue where he wound up getting an admonition. But in the opinion of the DRB, they define pattern as more than 2 instances of gross neglect. Now, that's a mistake by the DRB, because gross neglect is handled under A. What they mean here is 2 or more instances of neglect. That's a pattern, which would be the reference to B. So what you may want to do in your notes is cross out the word gross, because it doesn't have to be gross neglect. If it were gross neglect, even one incident of gross neglect is actionable under 101A. So 101B, you've got to have 2 or more incidents of negligence, ordinary negligence, and that's going to constitute the RPC. 747 reported cases that have as a collateral issue RPC 1.1. There's no cite to New Jersey reports on the Amatia case because all you got was an admonition, but there's the docket number for it. Typically, when you have this, you know, if you've made good on your making the client whole, you're looking at a reprimand, okay? And suspensions where there's multiple instances of serious harm to a client, or you know, those with a long disciplinary history. Now, diligence, as you can see, is kind of like the other side of the coin from competence. Reasonable diligence and promptness in representing a client. You're supposed to finish out the work you're supposed to do. So this would involve also, you can see how this would have application to letting a statute run. But if you look at the case law, this is coming out of one of the DRB opinions where they're going through and reviewing all the case law that deals with this stuff. So let's say human, what did this guy do? Failure in a real estate transaction to record a deed and mortgage for 6 years, and failure to insist that the seller's spouse sign the deed, that it was gross negligence. Failed to prepare for and notify a client of a settlement conference, that's 1.1 and 1.3. And Yetman, holding that the attorneys failed to work actively in the administration of the state, conclude the matter within 3.5 years, or refer the matter to another attorney after recognizing to be beyond his competence constituted gross negligence and a lack of diligence, okay? But you can see how they always link 1.1 and 1.3 together. You don't find these in isolation. Plus, there's others that go into it as well. But that really should give you an idea about the obligation of diligence. And again, you can mitigate this by trying to make the person who was injured whole. All right. I want to talk about GSCLE for a second. And everyone who's involved in the municipal court process should be familiar with the GSCLE case, starting with you. Wouldn't be a bad idea for you to take a look at it as well. GSCLE is the Supreme Court's seminal case dealing with diligence in the municipal court setting. And it is an example of literally the perfect storm. You don't get things like this coming together very often. Let me kind of give you a very bare bones description of the facts of the case. Our story begins with a judge of the Superior Court. Remember, this is going to be a perfect storm case, okay? Driving his car. In front of him is another vehicle that's driven by his son, okay? The vehicle driven by the son, it has some mechanical issues associated with it where really the vehicle should not have been on the roadway, okay? The son, this being a perfect storm, of course, is a doctor, an MD, okay? During their little caravan, the son gets involved in an accident with the judge while driving the judge's car, with the judge behind him, and kills an individual who's the son of a police officer. Other than that, it's a perfectly routine case, okay? This is in Camden County. So the prosecutor's office, of course, since there's a homicide, gets involved in the case, and I imagine they very thoroughly investigate it and make a determination that there's no evidence of any recklessness. So there's no criminal charges here, you're just left with traffic tickets, okay? Now, at this point, since there's a judge of the Superior Court who's the defendant, the judge gets charged along with the son, the case is transferred out of Camden County to the next county over to Burlington County. And since there's a judge of the Superior Court who's the defendant, those cases always get heard in Superior Court. They don't get heard in municipal court. So now the question is, who's going to prosecute this case, okay? The Burlington County Prosecutor's Office says, listen, we don't do this kind of work. It's not our case. It's coming out of Camden. We're not responsible for it. The Camden County Prosecutor's Office says, listen, it's a municipal court case, and by the way, it's in Burlington County now. It's not our problem. The municipal prosecutor then is kind of tasked with the responsibility of doing this, but he doesn't want anything to do with it because nobody's going to pay him to go and put on this big mess in Burlington County. If it's in his court during his session, that's fine, but not for something like this. This is really the responsibility of the Attorney General. So he contacts the Attorney General. They're not interested in doing it. Obviously, Burlington and Camden don't want to do it for the reasons I've just told you about. So very reluctantly, he's like stuck with prosecuting this turkey. So on the day of court, he just treats it like any other municipal court case that he would ever do. He just shows up and let's see what happens, okay? Because that's how municipal court works. You're dealing with part-time people who have zero staff, zero resources, and you just show up and do the best you can, knowing that 1 out of every 10,000 cases is going to require a little bit of extra effort. He shows up and he is greeted by a crowd of people who are there for the defense of the case, victims, witnesses, and things of that nature. And the only person who's shown up from his side is the complaining police officer, who's brought a huge stack of papers, discovery, and things of that nature, all of which he was totally unfamiliar with. And he sees he's kind of got like a tiger by the tail here, that he needs a lot more witnesses and a lot more time to prepare this case. So he does what all prosecutors do in municipal court. Confident that he would get what he wants, goes in and speaks to the judge and says, you know, I need adjournment. I'm not ready to go on this. And the judge says, no, that's fine. You can have 10 minutes. Go talk to your witness and then be prepared to start the trial, okay? Now, I have to tell you, the Supreme Court really kind of criticized the Superior Court judge who made that call. The better way would have been to adjourn it, but, you know, it was an exercise of discretion. There's not a whole lot they could say about it. So he spent a couple seconds with his officer, put on the best case he could under the circumstances, which was not much. At the end of the day, the Superior Court judge winds up getting convicted of a violation of 39-344, which is the general equipment violation. And everybody gets acquitted of everything else. It's an utter and total miscarriage of justice. All because the prosecutor was completely and utterly, I don't want to say sandbag necessarily, but just thought that this was going to be handled like any other municipal court case and didn't put the time and effort into getting ready. You can't be involved in situations where you embarrass the judiciary this way and expect you're going to get away with nothing happening. It just doesn't work that way. And this was a terribly embarrassing incident for the judiciary. And the prosecutor, of course, had the responsibility for putting on the state's case, and he's the one who had to take the blame for this. So the case basically is, a treatise on 1.3 in the sense of what they expect from prosecutors generally in municipal court. And even though there's a recognition that municipal court is, it's kind of a relaxed, informal environment, that doesn't change the fact that prosecutors have an absolute responsibility to be prepared, to be professional, and to prosecute these cases in a way that their client, the people of the state of New Jersey, would expect them to do, competently and diligently, all right, which did not happen here. So the net result of this wound up being a reprimand for this guy and a kind of a big embarrassment for everybody. But this was just a lose-lose situation from everybody's perspective. And I'm just amazed at the number of prosecutors that are not aware of the GSCLE case. There's no curriculum to train prosecutors, which kind of shows me that they don't take it all that seriously. You kind of alluded to it before. You could easily get a young prosecutor walking in off the street who's appointed for political reasons and has no experience at all, and there's no mechanism to train the individual. They're just kind of...
Other than DWI, I guess they have some training.
Yeah, but I mean...
With that alone.
Exactly. And...
what should the prosecutor have done then?
If a case is in Superior Court, okay, it's an extraordinary case. At least you're going to find out what it's about, all right? Find out what the guy's charged with. Talk to your cop. What happened here? Why is this in Superior Court? You're going to be prosecuting a Superior Court judge. I mean, he had the indicia that this is an unusual case. Pick up the phone and call somebody. He did pick up the phone and call and try to pass it off to a bunch of other people. And ultimately, when he had the responsibility, he made an affirmative decision that he was just going to show up and find out what was happening, as opposed to, being diligent and finding out and preparing the case for trial. I think there was a lot of resentment too, because he wasn't getting paid. It's a part-time job for prosecutors. Nobody's going to give them extra money to spend the 3 or 4 or 5 hours to track down their witnesses, prepare them, get them ready for trial, as you would expect when you're dealing with full-time prosecutors. That's their career, and that's what they do for a living, so it's no problem. They got to be working for 8 hours anyway. They might as well be prepping up a case.
Who brought the complaint in Siegel?
I don't remember, but the bottom line was a big problem for somebody. All right, so that's the Siegel case. Now I want to talk about 1.4 for a couple seconds. 1.4, in large measure, deals with prospective clients, people who have not yet quite become clients, and that is in paragraphs A and C. Let's take a look at A for a second, because notice that A is geared in particular to prospective clients. A lawyer shall fully inform a prospective client, of how, when, and where the client may communicate with the lawyer. So you've got a guy coming in, he's thinking about hiring you. You have an affirmative obligation to tell this guy, for the future, if you want to contact me, this is how you get a hold of me. Call my office, call my cell phone. My own personal preference is email, and more email, that your clients can communicate with you that way, because you have a record of it. You can respond when it's convenient to you. You can respond in a cursory manner. And the most important thing from my perspective is it creates a record, a permanent record that you were, in fact, responding to your client. For those of you who have websites and you have on your website a function which allows people to ask you questions through email, a lot of attorneys have this. The case law around the country, there's nothing in New Jersey yet, but around the country imposes RPC 1.4A on attorneys who do this, because these are prospective clients, so you have to give them a mechanism, once you've opened up this two-way channel of communication, that they can get back and forth with you and communicate with you. Also make sure, by the way, because RPC 1.6 is implicated here, that you maintain confidentiality of communications coming through the website. Make sure that nobody else has access to what the client is asking, nor the answers that you're giving. And finally, make sure that the answer that you give to the client's question comes from a licensed New Jersey attorney as opposed to a secretary or your brother or some guy off the street, okay? Because all of these things are implicated. These individuals are recognized to be prospective clients. Let's just take a look at C for a second. C also deals with prospective clients. And this it really goes to where this comes up is in retainer agreements for the most part. A lawyer shall explain a matter to the extent reasonably necessary to permit the client to make informed decisions regarding the representations. Once in a while this comes up in the criminal context where you don't explain to a client what his options are during the course of criminal representation or a trial, although normally the remedy for that is post-conviction relief as opposed to prosecuting some type of RPC violation. Most of the cases involving C involve problems with the retainer agreement because the client really can't make an informed decision about representation unless he knows precisely what are the terms and conditions of the retainer agreement, what is the attorney going to do for me, what are my obligations to pay legal fees, when am I required to pay them, what's going to happen to the money that I give to the attorney, is it going to go in the trust account, is it going to be billed periodically, or is it just one flat fee that's going to be paid all at once? What will be the sanctions if I don't pay the fee? You know, all these things have to be spelled out in the retainer agreement. And in the absence of either any retainer agreement at all, or alternatively an inadequate retainer agreement, you run into problems with C, okay? Now, in the criminal context, one thing you got to remember, and I've had this come up several times, when you're in the midst of a trial, clients really only have, criminal defendants only really have two issues that they have any right to be involved in at all. And they are, number one, how are you going to plead? You going to plead guilty or not guilty, all right? Only the client can make that decision. And number two, which is a kind of a recent vintage, is the client going to testify? That is a secondary decision that only the client can make. Notwithstanding the fact that it might not be tactically or strategically wise for the defendant to do it, that's something that's purely within the province of the defendant to decide. The attorney doesn't get to make that decision. He can advise, but ultimately it's up to the defendant to make that. Every other decision in the course of a criminal trial is the responsibility of the attorney, not the defendant. The defendant doesn't have any say on how the attorney is going to exercise his discretion. You may consult or try to explain to the extent you feel necessary as defense counsel, but your client really doesn't have any role to play apart from plea and whether he's going to testify. So you got to think about that in the context of C, because the client really doesn't have any informed decisions to make except for those two in the criminal context. How am I going to plead? Am I going to testify? Okay? That's why there's not a whole lot of case law on that. Most of this comes from defective or absent, usually absent, retainer agreements. Now, I want you to look at B for a second. We have to parse this because it's defined by two words, reasonably and reasonable. This deals with your obligation to provide information to clients. And notice, your obligation to keep a client informed is only reasonably informed, okay? It doesn't mean that every sparrow that flaps its wings has to be, you have to tell your client. Only has to be reasonably informed about the status of the matter, okay? Secondarily, when do you have an obligation to promptly provide information to your client with information about the case, okay? And that is triggered by a reasonable request. So if your client's requests for information are unreasonable in the sense that they come every hour on the hour or through constant telephone calls or endlessly long emails that you get every single day, the argument is it's a request for information, it's just not a reasonable request for information, okay? Just like the client only needs to be kept reasonably informed. That doesn't mean every day. If you're dealing with a personal injury case that's going to go on for years, it may mean monthly or every 2 months or whenever something of significance happens on the case. That would be reasonable under the circumstances. So don't be bullied by clients, all right? The provisions of B are really kind of predicated upon reasonableness. Now D comes up occasionally where your client wants you to do something that's unethical. I'll give you an example in my own life. I have a drunk driving case that I'm doing now, and the woman who I'm representing is insisting that I file a motion to dismiss her case because it's 5 months old or something like that, drunk driving prosecution. And I'm not going to do it. I just refuse. It would be, in my estimation, it would be a frivolous motion, a violation of RPC 3.1. And I've told her I'm not doing it. Why not? Because your case is only 5 months old. And oh, by the way, the vast majority of the adjournments in this case have become because of you, for not showing up for court and for being inconvenienced and going on vacation and things like that. And if you look at the case law, this is just not a significant delay. Okay, I'm not doing it. I'm not going to waste everybody's time filing a frivolous motion. And by the same token, what you could say to your client is, but you're a layperson. You're not obligated to follow the RPCs. They have nothing to do with you. Unless you take the bar exam and get sworn in, you're not bound by the RPCs. You can file all the motions you want pro se, and the judge will decide it and rule on the merits. If you want the judge to, consider dismissing this case on the basis of you were denied a speedy trial, knock yourself out, file a motion. And the judge will consider it and rule on it, okay? It's just I'm bound by the rules of professional conduct not to do that. So this is where D is implicated. And I'll just give you an example where the RPC violation would be 3.1, but it could be anything, all right? This is where D comes up, and basically you can't let your client do that. You got to tell them that, I can't do that because it would be a violation of the RPCs. Everybody cool? All right. 867 decisions, applies to prospective clients as well as regular clients. Oh, I mentioned this about not communicating a settlement offer. That happens under C, where you're in like a personal injury case and the insurance company's made an offer to you and you just reject it without communicating it to your client. Well, you get this in the criminal context too, where there's a plea offer extended to the defendant and the defense attorney just rejects it outright and never informs his client or talks to his client about it. You get that under C because the client can't make an informed decision because he hasn't been given the raw information. All right. And I mentioned before, you'll see that this is charged a lot. When you get this, you're always going to get 1.1 and 1.3 as well. All right. Okay. So I was teaching this class one day to an enormous group of people. There had to be 200 of them there, up in North Jersey someplace. And we took a break. And I went in the men's room and went in one of the stalls so I could shoot up. And while I was in there getting my syringe ready, I hear all these people coming into the men's room, all right? And they're talking, jibber-jabbering about. And we had just done this part of the lecture before the break, and they're all saying, holy mackerel, I don't do that, I don't do this, I don't do this, I don't do that. I mean, it was like caused like this tremendous panic among all the attorneys who were there. There's just an enormous lack of knowledge associated with what we're going to be talking about now. And it's not so much RPC 1.15 that's the problem. It's the associated court rule. I think you should look at RPC 1.15 as something that is strategic in nature, and the court rule that implements it, which is Rule 1:21-6, as tactical, all right? So 1.15 gives you in broad strokes what you're supposed to do, but the actual details of what you have to do as a New Jersey attorney are spelled out in, again, painstaking detail in RPC 1.21.6. Let's talk for a couple seconds about trust accounts. Because of the problems with Wilson, and the invariable outcome of Wilson cases, it's important that you run your trust account properly. Remember, even negligent or reckless misappropriations will wind up getting you disciplined in some way. If you handle your trust account properly, you're never going to have a problem. Now, what are the ways that the Office of Attorney Ethics gets into your trust account? Let's kind of go through them. The first way, in no particular order, is by the random audit program. The Office of Attorney Ethics takes an enormous amount of pride in their random audit program, and every year when they list the people who've been disbarred because of trust account infractions, they'll always put how they got involved with this guy, and if it was from a random audit, they'll say this came about as a result of the random audit program. I guess that's done in a way to kind of show the importance of the program. The random audit program has really two functions associated. One of them is to uncover defalcations, like we've been discussing. But another one is that there's just a pure educational component associated with it. The people who come in are really supposed to not only kind of audit you, but also to give you instruction on mistakes that they see have been made or technical errors that you've done. And they'll always find something. Nobody's going to be able to get away with, having a perfect trust account unless you've been audited recently and implemented all the changes that they've suggested. And it can be very minor stuff like the wording you have on your trust account, or it could be the number of checks on a page, things of that nature. It'll be during this time period, for example, they'll ask you about liability coverage, and if you don't, not liability, but malpractice coverage, and then if you're an LLC, they're going to want to see your policy because you can't carry on business as an LLC without that type of insurance. So when you get a good auditor, it can actually be beneficial because of the teaching component associated with this. Anybody ever been through a random audit? What was it like? Your office is pretty much together. I can't imagine you would have had a problem.
Just educational. Twice I've had them.
Twice. And did they find anything in terms of they wanted you to make some minor corrections?
Minor things, fortunately.
Well, they got to find something. How would you describe the attitude of the people who came?
Educational, friendly.
Good.
I thought.
See, it takes all kinds of people, and sometimes you get an individual who doesn't really get it. They're very adversarial, suspicious, prosecutorial in nature, and you get an individual like that, it can make everybody's life miserable. They really antagonize people when they come in with that kind of attitude. Now, just a couple words about the random audit program. It's based upon telephone number, so theoretically every entity in the state has an equal opportunity to become subject to an audit. They just put everybody's, all the private practitioners' telephone numbers into a system that randomizes them, and then if your number comes up, literally, you're going to be subject of an audit. This is meant to ensure fairness, but I have a feeling that there's probably a better way to do it. If I were running the show, I would be focused primarily on solo practitioners. The reason for that is because it takes an extraordinary combination of skills to be a successful solo practitioner, because you've got to do everything yourself. You've got to be, promoting yourself, handling conflicts, representing clients, handling the vicissitudes of cash flow, doing all the bookkeeping work, all the filing, all the, the keeping their files up to date, keeping your clients informed, communicating with your clients. That's a lot of work, okay? And for somebody who doesn't have any training in it, or even worse, no aptitude for it, because they don't have the ability to pay attention to detail, and I'm not saying that's a bad thing, it's just how God makes people, okay? It's what happens. But if you have that, the likelihood of you screwing up your trust account or not paying attention to your trust account or going for weeks or months without reconciling your trust account and your business account as well is much more probable when you're dealing with solos. And I find the number of people who end up being disciplined for trust account issues are the vast majority of the time solo practitioners. All right, so it just takes a certain skill set to be able to do it, and I don't know that it's something you can actually learn. I think you either have it or you don't have it. Okay, is anybody here solo? Nobody would be a partner with you, so you have those skills, right? Why are you laughing? All right. Getting back to RPC 1.5. Oh, a couple more ways to get into your trust account. One of them is by bouncing a check. Every bank that that handles trust account money has to be a New Jersey banking institution, because this way, there's a couple things. First of all, the Supreme Court has to freeze your account. They have territorial jurisdiction over the location of the money. But more importantly, they can require the banks, if they're going to go out and take these monies and hold them in interest-free accounts or interest-bearing accounts, which is, many, many millions of dollars. The bank has to agree to comply with Supreme Court regulations, one of which is that if there's a check that bounces out of the trust account, that has to be reported to the Office of Attorney Ethics. My advice to everybody is if you ever accidentally bounce a check out of your trust account, you should take very aggressive action to identify what the problem was, implement procedures to make sure that it never happens again, make up any deficiency in your trust account right away, and then immediately write a letter to the Office of Attorney Ethics and explain to them and document to the extent you can what happened. If it was a bank error, for example, or something of that nature, money went in the wrong account by mistake, whatever it is, show them what it is and then indicate to them in your letter what you're going to do in order to avoid this happening in the future. If they're satisfied with your documentation, typically that'll be the end of it. But more often than not, the attorneys don't adequately explain it or don't explain it at all, and then the Office of Attorney Ethics will come in. They're going to want to look at your books and records and try to get to the bottom of what happened that caused the check to be to bounce out of your account. This is an indication sometimes of much more serious problems where you might have, there's a word for it, it's not check kiting, but they have a word for it, I forget what the word is, where you're, like, say you're taking money out of your trust account to gamble in Atlantic City and you're getting it from real estate closings. So you did a closing today and you're going to take this money today to go to Atlantic City, and then you'll pay off the mortgage and the other things. From the next closing you do, you'll take their money and use that to pay off this mortgage. And it requires, like a Ponzi scheme, it always requires a steady stream of people coming in with new closings for you to be able to do it. There's a word the Supreme Court has for it. I don't remember what it is, but you guys kind of get the idea. This is uncovered when there's a check that bounces. You may also want to have a certified public accountant come in and look at your books, make sure everything's reconciled, if there's any other errors that you didn't pick up on. They'll always be very impressed when you've had your books looked at by a CPA. Let's take a couple seconds and just go through 115 quickly. So here's A. You have to hold property of clients and third persons that come into your possession in an account separate from the lawyer's own property. Funds shall be kept in a separate account maintained by a financial institution in New Jersey. So again, for freezing the account, for compliance with bouncing checks, and for IOLTA. These are all reasons why they require the institution be in New Jersey. Funds of the lawyer that are reasonably sufficient to pay for bank charges may be deposited therein. So you can't normally commingle your own funds and trust account funds, except to the extent to have these money in there to pay for bank charges. $250 is the cap on that. You can keep as much as $250 in your trust account to pay for those costs, okay? The rest of this stuff is, oh, by the way, here's the 7-year. This is in the Rule 1:21 as well, but there's a 7-year records retention requirement, so don't be shredding anything unless it's 7 years. And that's not only just for the files, but all the accounting information associated with it, your check stubs, your bank statements, everything has to be saved for 7 years. And of course, then here's your requirement affirmatively to take money that comes in your possession from a client or a third party, in other words, an escrow, and to segregate it and maintain it in the way that's set forth in the RPC. Okay. I want to kind of just mention a couple of extensions on Wilson. One of them occurred at In re Hollendonner, where the Wilson rule was expanded to include escrow accounts. Did you know Anton Hollendonner? Do you remember him? No. He's a Mercer County guy. He was an escrow agent and had money from his client as well as another stakeholder in the escrow. He asked for permission from his client to remove his fee in advance of doing any legal work on the file, which the client said okay, but he never checked with the other stakeholder, and that's what wound up getting him jammed up. The court made the Wilson rule prospective in these escrow accounts. They suspended him for 2 years for being basically stupid, and then said, from now on, anybody who involves himself in this is going to be subject to the Wilson rule. I don't know that there's been one of those cases associated with Wilson, but the Wilson rule definitely applies as a result of the Hollendonner case. Now, there's one other extension of Wilson, and it deals with thefts by attorneys in 2 instances. Either diverting fees that belong to the law firm or falsifying expenses, okay? Each of those 2 types of misconduct will result in disbarment now under the Wilson rule. And the reason the court has for coming up with this idea is because the level of trust between an attorney and his associates or between partners in a law firm has to be at least equal to the amount of trust that exists between attorney and client. And when you have an attorney in the firm who's really kind of ripping off his own firm, ripping off his partners, this is an individual who really cannot be practicing law, because law firms exist on this level of trust between and among the members of the firm. So for those reasons, the court has extended the Wilson rule to attorneys who engage in that type of misconduct. Again, diverting fees or falsifying expenses, all right? All right. What I'm going to suggest that you all do is, when you get back to the office today, at some point, spend a few minutes and look at 121.6 and just make sure you're doing in your practice everything that's in the rule. In particular, make sure that you're reconciling your trust account every 30 days and that you have a triple verification. There's three numbers that should always be the same. The amount of money in your trust account, bank account, has to be exactly equal to the amount of money that's shown in your trust journal, and has to be exactly equal to a trial balance of all the individual ledger cards you have for the clients you're holding money from. So let's say you have $50,000 in your checking account. That means if we take each individual card for every single client that you're holding money for right now and add them all up, they have to total precisely $50,000 as well. And then you would take your trust ledger, which has all the daily activities, or your journal, trust journal of all the daily activities, and that should also net out when you have a running balance at $50,000. That triple balancing is what shows that you're in trust. If one of these numbers is different, you're different by definition, you're out of trust and have to get in there and try to find where the mistake is. It could be a deposit that didn't get credited, it could be an arithmetic error, it could be a million things, okay? The bottom line is, though, every 30 days you're responsible for reconciling your trust account, okay? That's just the way it is. I think your business account you only have to reconcile once every 90 days, but the trust account every 30 days. 121.6 tells you step by step what you need to do in terms of the maintenance of your trust account, the type of financial institution you have, your responsibility under IALTA, the idea of how long your records retention is, how you can maintain them. Notice they only want 2 checks on a page. There's the 7-year requirement for everything, and it includes not only the client records, but also the banking records will have to be saved for a period of 7 years. All right. Here's the other things they want you to save: copies of retainer agreements, billings, ledger cards, invoices sent to the clients, records showing payments to attorneys and investigators. Okay. No ATM card. No overdraft protection. These are banned. You can't do these things, okay? By the way, it's not in here, but I'm going to tell you, no checks to cash. No checks made out to cash out of the trust account, okay? Also, the check can only be signed by a New Jersey attorney at law. It cannot be signed by the secretary or paralegal or anybody like that. Only attorneys can sign trust account checks. One quick thing I want to mention to you deals with unavailable, not the availability of records, but I think I want J. J is what I want. Unidentified money. You guys remember the store Unclaimed Freight? Remember that? Remember the guy used to go on the radio? Unclaimed Freight, right? Remember that? Unclaimed Freight. Well, this is going to be unclaimed money. You have money in your trust account associated with names, except that these people are long gone. You have no idea where they are. You can't get a hold of them. And you're not sure whether the money belongs to your client or to you. It may be client money that you've just been holding for years and years and years. Alternatively, it might be your money in the form of expenses that you never recovered, okay? Here's my legal advice to you. Unless you can demonstrate beyond a reasonable doubt that you have entitlement to that money, and you can document it so that no one's going to question it, you got to give the benefit of the doubt to your client, say it's your client's money, okay? In the absence of your ability to be able to demonstrate that it's a fee that's due you or a reimbursement of expenses that's due you, you're dealing with a Wilson violation, okay? You've got a knowing taking of money from a client that you're never going to be able to get permission from because he's disappeared. Now, 121.6J provides the mechanism for getting that stuff out of your trust account, okay? If you read it through, it tells you step by step what you have to do. your attempts to locate the client, to ultimately get the money, take it out, document who you're taking out and how much, and send it over to the clerk of the Superior Court. All right? And the clerk of the Superior Court will then keep the money in perpetuity so that the guy ever shows up, go talk to the Superior Court clerk. It gets the money out of your trust account because, number one, there's two reasons why you can't leave it. You can't leave dead balances in your trust account. You got to be able to account for the money, and this is money you can't account for. That's number one. And number two, if it's on the off chance that it is your money, you can't be commingling, fees and money belonging to clients. Okay, so by getting rid of it and sending it over to the clerk of the Superior Court, you eliminate that issue. And people have been practicing for a long time. Sometimes they'll have thousands and thousands of dollars for it's just unidentifiable, especially if you've had a practice that was very heavily into personal injury or real estate, where there's a lot of activity in the trust account. Sometimes things just kind of get lost in the shuffle. Doctors don't get paid, clients don't get their full fee, that type of stuff. Okay, so 121.6J is the rule for getting this stuff over to the Superior Court Trust Fund. Okay, very important. Clear it out of your account. Okay. Just a couple more quick ones, guys, before we conclude. I just want to mention, this comes up in municipal court a lot, it's 3.3. 3.3A5 was construed by the New Jersey Supreme Court in the landmark decision of In re GSCLE, a case involving an attorney who did not reveal to the municipal court judge that his client, who was pleading guilty to reckless driving, had additional charges that arose from the reckless driving incident, specifically double homicide. And by taking the plea, the judge basically immunized the guy from being prosecuted for aggravated manslaughter, death by auto, or whatever there was, whatever offense that they would have charged him with that had recklessness as an element. This would have set up a double jeopardy defense. The specifics in the facts in GSCLE enabled the plea to be withdrawn because the judge never elicited a factual basis out of the defendant. And within a year or so after the Supreme Court's decision in GSCLE, the legislature came out and enacted a statute which makes a plea that is taken following a death or serious bodily injury void ab initio. These cases have to go to the prosecutor's office, and the municipal court is basically divested of subject matter jurisdiction until such time as the Superior Court vests jurisdiction in the municipal court. Again, these are cases involving death or serious bodily injury. And by the way, it's irrelevant who's hurt. Even if the defendant is the one who's hurt, it still has to go to the prosecutor's office. And the Superior Court is actually the body that vests the jurisdiction in municipal court. So these come up all the time under 5 because GSCLE is not a particularly well-written decision. And it's a little bit of a confusing decision. It was written by Chief Justice Porritz. This is an example of one of those cases that really was a big, big scandal and required Supreme Court intervention and a published decision. Where it comes up is in a couple different areas. In the drunk driving context, where the lawyer, the defense attorney, knows that his client or suspects that his client has other convictions out of state, which are not obvious to the judge. The judge may be only having a New Jersey abstract which doesn't show any prior offenses, and the attorney knows that because his client told him that he had 2 offenses for drunk driving within the last 5 years in Oklahoma. What is the obligation of the attorney to tell the judge that? Does the attorney have the right to remain silent? Does the client have the right to remain silent? Or will this be basically a violation of 5, okay? It's a difficult call. GSCLE is not particularly helpful on it. I think a more helpful case in the sentencing context is the United States Supreme Court decision, Mitchell versus the United States. I'll give you the site on that. I think it's on the next page. Standing for the proposition that defendants who are pleading guilty, apart from offering a factual basis for their plea, have the right to remain silent, and that no inference can be drawn against them from remaining silent. So you start with the proposition that the state is the moving party at sentencing. If they have some information they want the judge to know, they can convey it to the judge. It's not the defendant's job to play a part in his own prosecution. and the defendant has the right to remain silent, and no adverse inference can be drawn from his remaining silent. So that's the holding out of Mitchell, and I guess that's probably what would protect you if your client had told you in confidence about prior convictions. By the same token, things that are of public record, that are in the newspapers, that are not subject to privilege, the defense attorney pretty much has an obligation under the GSCLE case to let the judge know about that, lest the judge be misled or do something that's inappropriate given the circumstances of the case. Okay. One additional thing on this, and you get this a lot in municipal court these days, deals with these 2C40-26 prosecutions. You have a guy who's been arrested for driving on the revoked list, and the cops just write him a ticket. And then when you're the defense attorney, you get into court and you see that your guy actually would qualify for the fourth-degree crime of driving on the revoked list following a drunk driving. But the police just didn't charge him yet, and your guy wants to plead guilty. Now, when you plead your guy guilty to driving on the revoked list in municipal court, that is going to constitute a complete bar to prosecuting him for the 2C40-26 offense, because driving on the revoked list is an element of the criminal offense. Okay, so he's pled guilty to one of the elements of it. It's double jeopardy. Do you have an obligation as a defense attorney, once you see that your client would qualify for being charged and prosecuted for that offense, to tell the municipal prosecutor or the judge, we want to plead guilty today, but we want everybody to understand if we plead guilty to this, it's going to knock the state out of the box for prosecuting the case. The distinction you should draw when this factor comes up, because remember in GSCLE, the aggravated manslaughter charges had already been written against the defendant when he walked into court and pled guilty. I'm talking about a situation where nothing has been written, either by oversight or inadvertence, but there is no criminal complaint. All you have is the ticket. So would it even be ethical for the attorney to say, time out, don't you guys want to write a ticket and charge my guy with a fourth-degree crime that's going to put him in jail for 6 months? I think that you can just go forward when the charge has not been written, because it's not your client's responsibility to dream up all the possible charges that the state could come back with him. Really, at some point, the prosecutor's got to take responsibility for these things. Okay? All right. Now, the only other one I want to talk to you about is 8.4. And 8.4 in particular, I want to talk about B and C, because these are very, very important. B and C are implicated when the attorney has been prosecuted for criminal or quasi-criminal act. When I say quasi-criminal, I'm talking about DPs and petty DPs, okay? Not traffic. For judges, yes, traffic generally, and drunk driving in particular. But for attorneys, you're really limited to being concerned about DPs and petty DPs and criminal matters. Here's the rule. It is a violation of the RPCs, 8.4B or C, to be convicted of a crime, fourth degree or higher, okay? Under certain circumstances, it may also be an offense to be convicted, or RPC violation to be convicted of a disorderly person or petty disorderly person offense, especially in the realm of domestic violence. This comes not through the RPCs, but through the case law. The Supreme Court has just taken a position that they're going to discipline attorneys who commit acts of domestic violence. Now, the law is not particularly clear as to whether or not they're talking about crimes of actual where somebody's getting assaulted, as opposed to harassment, lewdness, criminal mischief, something like that, where there's no physical harm to another human being. But here's what you need to remember, and this is the key. If somebody gets convicted of a DP, petty DP, or a crime, that conviction constitutes conclusive proof of the violation of 8.4. You are collaterally stopped from raising defenses to the charge. You can't defend yourself on the merits because the conviction constitutes conclusive proof, okay? So when you have those types of cases, the only thing you're going to be able to advocate is mitigating factors, things that will lessen the level of punishment. Excuse me, that's incorrect. Lessen the level of discipline. Don't say punishment. It's unprofessional. It's not about punishing anybody. It's about protecting the public. So utilize words such as the amount of discipline, the quantum of discipline, the level of discipline. That's what you should be talking about. And you never talk about punishment in the disciplinary context. But all you'd be permitted to argue is that your guy's entitled to less discipline as a result of whatever the factors are. You're not going to be able to litigate in any way, shape, or form the underlying facts. That ship has sailed based on either the plea or the finding of guilty that resulted in the conviction. Now, I'm going to suggest to you, although the court rules indicate, and I'll show you here, under A1, an attorney who's been charged with an indictable offense in this state or an equivalent offense in any other state has to promptly inform the director of the Office of Attorney Ethics in writing. My practice on behalf of clients who are attorneys who come in to see me is I always tell them about DPs and petty DPs as well. And I do this because, especially if it's a domestic violence matter, if there's almost mandatory discipline in those cases, but more importantly, they may decide to jump all over some DP or petty DP and try to impose a level of discipline. And I don't want it, said about my client that he was trying to hide that from them. I'd rather put it up front, confident that if he can resolve it in a civilized fashion, that the likelihood is they won't do anything, especially if it doesn't implicate, any harm to a client or something of that nature. But you really should be reporting these things all the time. I just had a guy the other day who had a bad day in, where was he? Woodbridge, and acted out. And I wrote a letter to the Office of Attorney Ethics just to tell them, and now it's resolved. He pled out to an ordinance violation. Nothing's going to happen to him, but you got to go through the process. And by the way, the same thing applies if you're disciplined in another jurisdiction where you're admitted. You've got to let them know, or there's a pending disciplinary matter in another jurisdiction. You've got to let the Office of Attorney Ethics know for the same reason. And the same rule applies, that whatever their decision is, conclusively establishes the RPC determination. So when you come over for reciprocal discipline, all you're talking about is the amount of discipline you're going to get. You can't relitigate the underlying factors that caused you to be found guilty of an RPC violation in the other jurisdiction. All right? And here's the court rule that says that there's the conclusive evidence of that establishes the RPC violation, and you can see down here the sole issue to be determined, and it's going to be the extent of the discipline to be imposed. Okay. If you guys will just indulge me for 1/2 a second, I do want to mention something about RPC 1.7. This deals with conflicts, and really kind of think about this. Conflicts occur in 3 situations, and they are denominated by stupidity, greed, and sex. Those are the 3 things that create these things. The stupidity deals with just acting like an idiot, dealing with friends, representing friends, and yet not having friends get independent legal advice when you and your friend are in a business relationship, okay? In other words, you and your friend are going to do something together, buy a house, condo, whatever it may be, and you're continuing to represent your friend and his business. And you don't say to the friend, listen, we're going to buy this condo together, but you should get independent advice because I'm an attorney and you don't have anybody representing you, so to speak, and I can't represent you and myself at the same time. When guys don't do that and things turn bad, when there's a fight, that's when you get disciplined for 1.7. Greed, an enormously motivating factor. Most of the cases, in my experience, deal with greed, where you want to borrow money from a client wants to borrow money from you, you see that the client has a really great opportunity and you want to get in on the ground floor. So all these negotiations you're doing with a client, and 2 things happen. You continue representing the client while you're doing business with him on some other level, and you don't advise the client about the necessity, it's indispensable, that he get independent legal advice before engaging in any type of transaction with you. Sex is the last one. Invariably, these things wind up bad. I shouldn't say invariably. I mean, every time I say that, someone in the audience says, well, I married a client, we've been married 27 years, and I say, oh, I'm happy for you. But for the most people, these things end badly, very badly. There's no prohibition against in carrying on a sexual relationship with clients, with the exception of appointed counsel in a matrimonial manner. They're not permitted to do it because these clients are particularly vulnerable, and this comes through the case law. But this is debated every year in Chicago at the ABA convention, and they have never yet come up with an RPC that bans sexual relations between an attorney and a client. But it has all the potential for an utter catastrophe, especially if as these things often do, it ends badly, all right? And that's putting it mildly.